Good morning, everyone, and welcome to our Weltman, Weinberg, and Reese webinar presentation today, Navigating the World of Collections, Foreclosures, Bankruptcies, in the COVID-19 world and beyond. I'm attorney Matt Urban. Most of you are familiar with me. Probably haven't seen my face in a little bit, and yes, my hair is still getting grayer, so that nothing's changed as far as that goes. But I'm glad that everyone's been able to sign up today. I know at the beginning of the year, I was thinking about what would be a great way to get everyone, to talk to credit unions again. It's been a while. Last year was such an interesting year with people working from home. It was funny, back in March of last year, I did a webinar for cross states on the writs of execution. It was like March 17th. It was right around the time everything was closing, and then it was like basically didn't hear from a lot of folks for the longest time, just because everyone was working from home. No one knew what was going on. Now again, a lot of credit unions, obviously, branches had to be open, people had to be in offices and things like that. So we've been a little bit different as far as that goes, but just thinking the beginning of this year would be good to start talking to people. Not sure if it's going to be live at any point soon. Although I'm hoping, I'm speaking at the Expand Expo out in October. Hopefully that will go forward. It'll be nice to be there and to see a lot of familiar faces. So thought it would be a good idea to sort of go over some of the basics. Talk about what's happening, what hasn't been happening. So I got together a couple friends, a couple of folks I work with, great attorneys who specialize in specific areas, and so we all sat down and got together and figured out, let's put this presentation together for our credit unions and give them some material, sort of refresher to kind of get back into things, because clearly courts are open, members continue to are going delinquent. There's a lot of questions about when you can foreclose, when you can't foreclose. Bankruptcies change. Just so much has changed. So we thought this would be a good refresher. And the thought is, hopefully, we'll get a lot of great feedback. And then, as we move forward, we hopefully like to do some more of these throughout the rest of the year, where maybe you hear Michelle talk about a specific hour on foreclosures, Gary talk about reaffirmation agreements on a Chapter 13 or something along those lines. Matt can talk about, maybe some state issues or whatever it is, so we're open for feedback, and hopefully this presentation will generate some questions, and we can get some individual ideas for future programs, maybe 1-hour webinars that would be helpful for folks. So, please make sure that, if you have any questions, obviously during the presentation, you can let us know. We'll go through those as we move forward. And then obviously, if you have any questions afterwards, you can certainly reach out to me, as I'm always happy to answer questions for anybody, and certainly reach out to any of my fellow panelists here today to be able to answer any of your specific questions. We're here to help. We're experts in these areas. We're on top of all the latest goings on. So, we're looking forward to this presentation. I think everyone will enjoy it. It'll be a nice refresher for everyone and get everyone up to speed. And we can move on and hopefully, again, like I said, cover more detailed topics as the year goes on. So with all that being said, people didn't come here to listen to me give a general speech to begin with. You want to hear some material from some folks. So what we'll do is we're going to introduce each of the fellow panelists here today. They'll give a brief introduction about themselves, and then we'll go ahead and turn it over to Matt to get into the substance. So Matt, why don't you go ahead and give a brief introduction and let the folks know who you are.
Yeah, good morning, everyone. Like Matt said, my name is Matthew Comey. I'm an attorney here with Weltman's Pittsburgh office, focusing on their legal collections group. Been here for about 3 years, focusing on all aspects of legal collections and creditors' rights litigation. Prior to my experience here, I did work with a smaller firm in the Pittsburgh area, focusing on credit union representation. So definitely familiar with the world of collections and how it affects credit unions. and we'll be focusing on the collection side of this presentation this morning.
Great, thanks, Matt. And in our office, he's known as Young Matt, and I'm now Old Matt. I'm not sure how I like that, but what are you going to do? Anyhow, our next presenter today will be Michelle Pirro. Michelle.
And I'm young Michelle. I will always be young Michelle. These two. I'm kidding. Hi, everyone. I'm Michelle Pirro. I am in the Pittsburgh office. I am handling the foreclosures for all of our clients in Pennsylvania. I'm licensed in Ohio and in Pennsylvania. I started my career in Ohio in collections defense, actually going against a lot of these folks, a lot of FDCPA and all that. So a little over a decade worth of practice time. I hate to admit that at times, but last year we are, and I am super involved in real estate in the office, outside the office, personally, commercially, all of that could go into it, ejections, landlord, tenant, all of that. So we're going to dive into a lot of that today, hit on some stuff that is pertinent to COVID. And I think that a lot of items that we're seeing more exponentially coming along with courts and all that I think would impact a lot of our clients and maybe even you in your personal lives if you have any investments outside. So we'll dive into that a little bit later.
Thanks, Michelle. And last but not least, we have Gary Masterson. He's not in Pittsburgh, but we won't hold that against him. But Gary's the bankruptcy expert. And Gary, why don't you say hello?
Good morning, everyone. So I am Gary Masterson. I actually practice out of our Cleveland office. I have been practicing with Weltman for about 14 months now. I've been licensed as an attorney in the state of California since the middle of 2014. Before I was with Weltman, I handled some state law matters in California, so I have that knowledge as well. When I joined Weltman in 2017, about 4 years ago, I was in a management role in the bankruptcy department. So I have both the attorney knowledge, I also have some operations knowledge. In addition to being licensed in the state of California, I handle our bankruptcy matters in Pennsylvania, also in Ohio, New York, and California. I'll go over a little bit of our network later on, but I also am able to file proofs of claim and reaffirmation agreements in every district in the country and Guam, etc. I am a graduate from undergrad of Ohio State, so for all of our Pennsylvania attendees, please don't hold that against me.
We'll try not to, but anyhow, thanks, Gary. Thanks, Michelle. And with all that being said, let's go ahead and get into the presentation. So, Matt, you're up, and take it away.
Thanks, Matt. For my portion of the presentation, we're going to be focusing on collection issues during COVID and navigating the world of collections with COVID and beyond. So we're going to first start with default prevention and resolution. And if that doesn't help initial cure efforts, and if they prove to be unsuccessful, we're going to talk about enhancing those collections through the legal process. And then we're going to talk about how to deal with cease and desist letters, as well as debt settlement companies and some strategies to deal with them, and how you can effectively leverage the credit union's position to maximize recovery with these debt settlement companies once you really understand how they operate. So first, when it comes to default prevention and resolution, if we could get to the next slide, please. The most important thing is to set yourself up for success early on in the process, because once the account goes into a delinquent status, the most important thing is going to be to bring that account current, gather information, and use that information to enhance your collection efforts. So everything you're doing in this collection world is going to come down to one of those three goals. So whenever an account is in a delinquent status, like I said, the first priority is going to be to get a payment on that account and to get it back to being current. Obviously, this is going to be sometimes easier said than done. So you should make sure that you have as much information at your disposal at the outset to make sure you're in the best possible position if and when a delinquency comes about. So when the loan repayment begins, you're going to want to get up-to-date employment status for the consumer. And now that's going to include whether or not that consumer is working from home, whether or not their hours have been reduced, maybe when they expect those hours to come back to normal, maybe when they expect to be back in the office. Any information that may be helpful down the road should you need to get in touch with that consumer. You'll also want to verify addresses, that's both physical and mailing addresses. So obviously, if there's a PO box in the mailing address, that's not going to be particularly helpful if you're going to need to worry about service down the road. So getting that physical address verified up front can be really helpful if you need that later. Then, of course, you're going to want to go through the consumer's contact information and verify phone numbers, whether it's cell phone or home phone, as well as email addresses that you can get in touch with that consumer at. And you want to keep this information readily available in your file so you have it at the ready should it become relevant down the road in an eventual delinquency. Like I said, you're going to want to use that information once obtained to make contact with the consumer as soon as a payment is missed or becomes late under the terms of the agreement or the repayment plan that you've set up with the consumer prior to. You're going to want to make regular attempts to communicate with that consumer. Now, as we've seen through COVID-19, more people today are working from home, or they've had their hours reduced, or something like that. That's going to affect how they're able to be contacted. So you want to stagger your communication attempts throughout the day to make sure you maximize your chances of making contact with that consumer. It's a little bit of a concept like the squeaky wheel gets the grease. So if you're constantly making contact with the consumer and they're seeing you come up in their emails or their voicemails or even mailings looking to cure this delinquency, you're going to be on their mind when they're deciding who and when to make payments once those are available again. So once contact is made with the consumer, you want to be sure to touch on all the most important pieces of information and update the information that you've obtained prior to at the beginning of the loan process. You're going to also want to make sure you touch on what the reason for the mispayment was. If it's a broader life event that's going to persist throughout a long period of time, or if this was just a one-time mispayment, maybe they forgot to put the check in the mail, or they didn't push the send button on their payment app or something like that. So just drill down to the reason for the mispayment. And then obviously you're going to want to go through and update all the information that's in the file. And that's going to include that employment status. And if there's if they're working from home, there's a potential they may have some additional disposable income because they're not paying for parking. Maybe they're not going out to lunch while they're at work as often. So not only could they be available more for contact, but they may actually have additional disposable income to devote to a repayment. So that's going to be key information for the credit union to know here. Next, you're going to want to update the family status. And that's whether or not the consumer is married, if they have children, maybe they have in-laws that are living with them, just to get an idea of the consumer's household. It's going to give you an idea of their expenses down the road. If they're married, it's going to alert you to potentially that the title of their assets could be an issue going forward. So you want to know what issues you're dealing with as soon as possible in these files. So you want to verify that information as soon as possible. And of course, you're going to want to go through and update the location information. You're going to update the physical and mailing address for the consumer, as well as the contact information, phone numbers, email addresses, and things like that. But the most important thing that you're going to want to do is to secure a payment. If we can go, yeah, there we go. If at all possible, at the first communication, you're going to want to secure an immediate payment over the phone to cure the initial delinquency. And in an ideal situation, you'll see a missed payment, you'll make contact with the consumer, they'll tell you, sorry, it's a one-time missed payment. I'll get a payment in the mail right now to cure the delinquency, and then that'll be done. But if that's the case, you're going to want to still see if you can set up future automatic payments for the consumer, just to remove that opportunity for that to happen again. If it's just a matter of remembering to do that, that automatic payment is going to save you a lot of trouble down the road and prevent the consumer from potentially forgetting a payment again in the future. Now, if there's no promise to repay, you're going to need to make sure that there's someone in charge of following up with the consumer and regularly reviewing the account. And that goes back to the squeaky wheel gets the grease. You're going to want to continually make contact with the consumer as much as possible. So if initial efforts to reach the consumer aren't successful, unfortunately, this is maybe more frequent. You're going to want to begin the process of confirming the information in your file right away, because you're going to need to contact that consumer later. So you're going to want to look in your file and see if the phone number that you have in the file is good. Have there been any good contacts with the consumer on that phone number recently? Or if they've all been going to voicemail, maybe the voicemail is just generic, or maybe the voicemail even identifies a wrong party. So you're really going to want to take a look at that. Importantly, if it's a cell phone, you'll probably want to note that in your file, because the CFPB has released proposed rules and guidance that may end up becoming relevant in the future. They've sort of been sitting around for a while, so we're not really sure exactly what's going to happen with them. But in the future, there could be an option for communication through texting. So it would be good to have that information in the file, so you know if that is an option in the future, you'll have the cell phone to text if that's available. Then you're going to want to see if any mail sent to the consumer at the address in your file has been returned. If it's been returned or refused, obviously that's not going to be a good address in the future. So you're going to want to try to find updated information to reach them in the future, or potentially serve them in the future if that's the route that ends up happening. And you're going to do that through skip tracing. And if you've determined that the information in the file is no longer valid, it's important to begin the skip tracing process as soon as possible. And there are many tools and services that are going to help go through this process. Some are even set up specifically to help you go through the skip tracing process. But the first one is the most basic one, and that's the credit report. So if you're permitted to pull a credit report, you're going to want to do that because that's going to have a lot of really relevant information, including location information for the consumer. It's also obviously going to have other information about the consumer's debt. So you have a picture of the other obligations that the consumer is potentially paying on, or maybe not paying on. So you'll have an idea of the consumer's financial picture that way. You could also get an idea of assets through a credit bureau report. You'll be able to see if there's potentially a mortgage on the file, potentially what that payment is like. You'll be able to see if there's a vehicle loan on the file and what that payment might be like and what status those loans are in. So overall, it's just a great resource, both for skip tracing and for just general collections. So that should be definitely on your list of skip tracing activities. Next is a post office check, and this is just going to confirm that the consumer lives at the address that you think they are. So it essentially is requesting the post office review their records for the consumer, and you're reaching out to the local post office for the address that you have and seeing if they have any changes made by the consumer there. They'll either tell you there's been no change or they've left a forwarding address, but they can also tell you the physical address that's associated with a PO box, which could be important as well. It's important to note that these post office checks do take some time, between maybe 1 or 2 weeks, but I have seen them last longer or take longer to go through that process, just depending on how busy they are. So it's important to do that first, just because you're going to be going through the other processes anyway. So while you're waiting for this post office check to come back, you can go ahead and try some other sources to find some information. And one of those next sources is going to be the internet or social media. And with social media, it's going to be really important that you only use information that is obtained that is available to the regular person using Facebook or Twitter or LinkedIn or Instagram or anything like that. You really can't pose as a friend to attempt to get to some of that more private information. That's just not something you want to do. Not only is that not allowed, but we've all seen people who maintain social media accounts that are just not an accurate reflection of the person's life. So even relying on the social media information could be potentially problematic. On the other hand, a Google search could pull up some decent public records and some information that you may be able to find just generally. It's probably not useful for you to spend too much time Googling. You don't want to go through 10, 12 pages of results. If there's going to be something that's relevant to your skip tracing efforts, it's most likely going to be in those first couple pages. So just search the name of the consumer in quotation marks and go through a couple pages. If there's nothing there, you're probably not going to find anything scrolling through more pages, and it's just going to be a lot of wasting time. You can also use the white pages. Oddly enough, are still being maintained. If you're not aware of that, they can still be a good resource for confirming both address and telephone information if the consumer is listed. But you'd be surprised how many people are still listed these days. So that's definitely a resource you want to check out. Court records can also be a good resource, but you usually have to go past the typical Google search to get access to these things, just because there's usually a privacy component in most jurisdictions with what records you're actually allowed to access. So this goes into going into the civil or criminal courts in the jurisdiction where you believe the consumer to reside, or you believe that the consumer may reside, and seeing if there are any pending dockets, either a divorce or a personal injury action or something like that, to where that's involved with the consumer, to where you could maybe pull that docket and get a good address for the consumer where they've already been served. So someone else has already done the work for you. You just go in and pull the docket and use their address that has already been proven to be good for service and take up that mantle there. It's important to note that different states and different courts have different levels of access to their public records. I can speak for Pennsylvania. It's the magistrate courts in Pennsylvania all have a unified judicial system, so you can always pull the docket for a magistrate court, for a magistrate court case. So you'll have that, at least the address information of where the magistrate has served the complaint on the consumer before. But counties in Pennsylvania are all different. So Allegheny County here in Pittsburgh, you can get online if you have a login, and you just have to pay a little bit of a fee there to get access to that information. But some counties just don't have any kind of access to the general public online, so that makes it a little bit more difficult of a resource to use in that way. Beyond court records, you can look for county property tax assessment records. This is going to be what the county views as the sort of taxable value of any kind of real estate. And it's going to identify whether or not the consumer owns the property where they reside or you believe they reside. So that's, if you have an address, you can look up, in most jurisdictions at least, who that property is registered for tax purposes. And it can also serve as the basis for a very rough evaluation of the value of that real estate. In Pennsylvania, there's a pretty common formula that you can use to transition from the assessed value for tax purposes to what they would consider a pretty low ball market value, but a market value nonetheless. and that information may be useful later when you're looking at assets. The Recorder of Deeds also has useful location information, but just because of the way that office operates, it's a little more difficult to search for that information on their records. If you've ever been to a Recorder of Deeds, wherever you may be, you'll notice that it's just a bunch of books that are just deeds piled up, and they may or may not be scanned into their system. But regardless of that, on the off chance that they are scanned in and are easily searchable, they can provide valuable location information for service down the road. So you can go ahead and make use of that service if they're available online in your jurisdiction. The Department of Transportation also maintains records. This is going to be vehicle registration, what address a particular vehicle is registered to. That could be a hint to where the consumer is residing, as well as driver's license information. It's going to have an address in there somewhere. So it would be useful to check there as well to see if you can verify an address or verify a vehicle registration. Again, coming back to an early look at assets for the consumer. Finally, there are plenty of subscription services that are paid that are sort of a compilation of public record searches. These can be very helpful, but they are also usually equally expensive as sort of get what you pay for proposition here. Two of the biggest companies that are commonly used by law firms as well are LexisNexis and Westlaw, but there are plenty of other services, and they all generally provide the same idea of service. So it's just a one-stop shop for all of these records that I just went through. So through one search, you can search civil, criminal records, other government offices, and each service pulls from various public records through online searches and just compiles them all into one list of results for you. So it is helpful to get all the information in one place, but there is a fee associated with that. So it's just something to keep in mind there. Additionally, excuse me, you want to be careful relying too heavily on these subscription services because while they are very good at compiling a lot of information into one result for you, it is dependent on there being public records for a person to actually compile that information from. So a consumer that's particularly young is not going to have many records to their name, so it's going to be potentially problematic to go through and attempt to see which records available for Lexis and Westlaw are accurate, or if there even are any. Potentially, an 18-year-old consumer with their first credit card loan, they're not going to have much out there on them. So these services are going to be are going to have a tougher time finding information for that type of consumer. On the other hand, there are people who have so much information about them that it's hard to identify what piece of information from these services are actually reliable and current. So you can trust these services, but you really need to verify the information as well through some of these other skip tracing practices that we've discussed. Okay. Excuse me. Now, if efforts so far while you're doing this skip tracing have been unsuccessful and the consumer's information has been confirmed, it's time to begin reviewing the account for what we refer to as enhanced collection activity. This option typically includes continuing to handle the account internally, essentially trying the same strategies that we've discussed before. You can turn over the account to a collection agency who will essentially ramp up the frequency of the strategies just discussed. You can turn the account over to a law firm to file a suit, which is going to essentially escalate the collection activity, or you can sell the delinquent account or delinquent accounts more likely to a debt buyer and just do away with the whole issue on your end entirely and put the problem all on them. And the way you decide on how to move forward through one of these options is going to be a little bit of a case-by-case review. There's unfortunately no overarching rule I can give you today. So I can't say if X then Y in these situations. It ends up being a little bit of a sliding scale to decide how to move forward. If we can get to the next slide. Thank you. So there are many factors to determine this, and we refer to those as the ABCs of collections. This stands for assets, balance, and collectability, but I always refer to that and remember it as always be collecting. It's a little bit snappier. The first item is going to be assets. So this is one area where the information you've gathered up front and through your skip tracing is going to really pay off. So you're going to want to try to develop a snapshot of the consumer's financial picture with the overall goal to determine the nature, the value, and the title of each particular asset in the consumer's name. So if they own property, then an eventual judgment is going to act as a lien against that property if it's in the jurisdiction where the judgment is held. This is going to increase your overall leverage on the account for eventual collection, which is really the goal of enhanced collections practices in general. If the consumer's employed, you'll be able to at least assume that they have some level of income that may be available in a repayment situation. So you want to see if you can verify either through your file or through other means whether or not they're employed, and potentially use that in your file with the credit bureau report and some other pieces of information that you may have to develop maybe how much disposable income may be available here. You also want to dig into the consumer's marital status. If the consumer is married, like we discussed before, it's going to make the title of the assets particularly important. Most likely, they're going to be titled jointly with their spouse, and that's going to frustrate future collection options, just because most spousal property is going to be pretty well protected unless both spouses are obligated on the liability. So that's just going to alert you to a potential issue going forward. But obviously, if you've properly collected information up front, like we discussed before, you would have already known that. And this step would just be confirmation that that's still something you want to look out for. So you'll also want to review past payments that you've received from the consumer. If they've paid by check in the past or even ACH or something like that, you're going to have a record of potentially where they bank, or at least where they banked in the past. And that's going to be useful going forward. If a judgment is entered, you could potentially attempt to execute on those bank accounts. So you want to see if you can't identify where those bank accounts are early on to inform your decisions going forward. Like I said, this basically is just developing an overall financial picture for the consumer, and it's just to help you determine how to move forward with these enhanced collection techniques in conjunction with the other factors here. The next factor is going to be the balance on the account. This comes down to reviewing the account to see if the balance that's owed justifies the action that's being contemplated here. So really, you're thinking about, does it make sense to spend the time and the money on a potentially small balance when there are other balances with the credit union that may be higher and maybe more readily collectible in this situation? So if it's a low balance, you have to take that into account when you're deciding how and if to move forward here. Finally is collectability. This issue gets to if a lawsuit is filed and voluntary payments are not made or settlement is not reached, you'll want to think about, does the borrower have any assets that are accessible through a post-judgment execution? And we'll go into a little bit more of what that may be here in a few minutes. But ultimately, you just review all of the assets that you've found and analyze whether or not they would be available for execution after. So you can see how this develops a bit of a sliding scale. You can have a situation where you have a big balance owed by a consumer that has a bunch of assets that you think are going to be readily collectible through execution. That's a no-brainer. You're going to file that lawsuit, you're going to get to a judgment, you're going to have a lot of leverage to eventually get to a repayment. But as everyone here knows, it's rarely going to be that black and white. You're going to have one or two limiting factors for some of these items that you're really going to want to dig into and use as a way to decide how to move forward. So maybe that consumer with the big balance is married. You're not sure how execution is going to go, so that collectability element is going to go down pretty heavily. So that's something you're going to have to weigh. And there are other factors in there that you can see how, one way or another, the credit union is going to have to come to a decision based on weighing their goals and the risks for each particular account. So it is a case-by-case review in this situation. So if you've gone through the review and you've decided to file a lawsuit, it's important to note that the analysis in this situation isn't completed. Within the legal process, there's still many things that you're going to want to consider before a lawsuit is actually filed. Specifically, you're going to want to go into what court to file in, whether it's at the county level or at the small claims court level. You're going to want to confirm your statute of limitations, and you're going to want to determine the proper venue for the lawsuit. So once collection efforts up to this point have failed, filing a lawsuit against the consumer is an effective way to enhance collection revenues. In most jurisdictions, including Pennsylvania, collection lawsuits can be filed in small claims courts or courts of general jurisdiction, which means these courts can hear pretty much any matter that's brought in front of them. And the reason why this serves to enhance collection revenues is because generally filing a lawsuit is going to get people's attention. So sometimes just filing a lawsuit will inspire a consumer to make contact with the credit union and attempt to resolve the issue just from the filing of the lawsuit. But if the lawsuit does not lead to a voluntary resolution, then the entry of a judgment is going to increase the credit union's options as well as leverage for future collections on the account. And this includes post-judgment executions, whether it's bank attachments or wage attachments, depending on your jurisdiction, and also liens against property. In general, like I said, it all comes down to increasing the leverage of the credit union on the judgment to increase the chances of overall collection on the account. So importantly, a lawsuit must be filed within the state statute of limitations. This is sort of an obvious concept, but it bears repeating because it is such a hard and fast rule here. The statute of limitations runs from the date of the last consumer initiated activity. So if they make a draw against the line of credit, if they make a purchase with the credit card, if they make a payment on the loan, all of this is going to serve to push back that statute of limitations. Pretty much anything that shows the consumer is acknowledging the obligation, which sort of makes sense with the policy of the statute of limitations. If the consumer is clearly aware of the obligation and addressing it or making use of a line of credit, it doesn't make sense for the statute of limitations to start before then, because you want them to continue to be involved in that account. So statute of limitations vary from state to state, so it's important to know the rules of your jurisdiction. Pennsylvania is 4 years, which is pretty standard. Most statutes of limitations range from 3 to 6 years for a sort of breach of contract action. So just review your state rules and get an idea of where that statute of limitations lies, and you're going to want to make sure that that date is prominently noted in your file, so you're not overlooking any of these statutes and accidentally filing some out of statute. So after you've gone through the ABCs and you've decided to file a lawsuit and you've confirmed that the debt is within the relevant statute of limitation, it's time to determine where to file the lawsuit. In particular, where to file in terms of whether or not it's at the county level or at a lower court level. This is an important element because where a lawsuit is filed is going to have wide-ranging impacts on your ability to successfully collect on the account. This is because by design, these different courts have different levels of power and different levels of authority. So you're going to want to choose the court that best fits the account and what's going to most help the credit union achieve their goals and lead to an eventual recovery. So that comes back to the case-by-case basis that you're reviewing on these ABCs. You can come back to that information to see which court may be most beneficial for you to file in. The main factors here that differentiate these courts are the filing fees, the balance of the account, the speed or the formality of the proceedings, as well as the execution options that are available should you receive a favorable judgment. And again, this sets up sort of a sliding scale of review so that the credit union can use that analysis to decide where best to file. So for small claims courts, these are often an option for collection lawsuits. At least in Pennsylvania, as long as it's under $12,000, you can file at the magistrate court. These courts generally have lower filing costs. They simplify and streamline their procedures, so the hearing ends up being a little bit more informational and a little more conversational, just with the judge talking to both sides and getting a basic understanding of the issues before they enter a ruling. These courts are also very settlement oriented, so they'll always encourage parties to talk. They'll always give parties additional time if they need to discuss a settlement. And that ends up being a pretty effective way to go about settling these matters, because a lot of times, especially at the magistrate court, this is the first time that the parties are forced to be in the same room at the same time. Unfortunately, this is changing now with COVID. Most magistrates are either moving to entirely virtual or remote appearances, or they're not allowing multiple people in their waiting rooms at a time. So before I would go in about 10-15 minutes early to a hearing, I'd have an opportunity to discuss a settlement with the consumer, and I'd either be able to settle that account before the hearing or get a better idea of the consumer's position on the account prior to the hearing, and better help collection efforts in the future. So with that changing and probably not coming back, it's just even more important to make that initial contact in the collection efforts. Aside from these changes, their procedures are generally more informal. They also have relaxed rules of evidence, so you may or may not need to send a representative to verify the particular documents that are going to be needed to enter a judgment. Thankfully as well, the adverse decisions of these courts can be easily appealed to the county level. So that's going to be another layer of security for the credit union there. If filing at the magistrate, you're going to want to be aware of the location of the magistrate or small claims courts. This is known as the venue of the action. It's important to make sure that the lawsuit is filed either where the contract was physically signed or where the consumer currently resides. So if they've actually signed the documents in the particular jurisdiction, you can file at the magistrate there. One example of a cautionary tale here is just from this last August with Northwest Savings Bank. You may be familiar with the settlement here. The Pennsylvania Attorney General entered into a settlement agreement after they alleged that Northwest Bank was essentially forum shopping and just filing all their collection lawsuits in Warren, Pennsylvania, despite that not being the proper venue in a lot of cases. And the AG used some pretty strong words that you can see here. He said, quote, "We will not let any business, big or small, exploit Pennsylvanians in pursuit of a ripoff payday." That's some really strong language and a pretty harsh condemnation of what amounts to essentially forum shopping here. So that's definitely going to be a big issue going forward. And while that accusation is pretty harsh, the remedies that Northwest was forced to go through as part of this settlement agreement are maybe even harsher. If we can get to the next slide. Northwest was also required to cancel any judgment that they obtained since January 2013. Just think about how many judgments the credit union has entered since 2013. That's going to be a lot. They've also been required to pay restitution or credit the balance of any consumer who paid amounts towards the judgments. So not even paid off, paid any amounts towards the judgment. So that's a pretty harsh settlement there. So be aware of those practices. So for our purposes, essentially what that means is filing at the magistrate down the street from the branch could be deemed a violation of Pennsylvania's consumer protection laws if the member does not either live in the jurisdiction that the magistrate is in, or if the contract, like we discussed, is not physically signed in that district. So you want to really pay attention to the venue choices that you're making if you're filing the lawsuits on your own. Now, I know a lot of you are probably thinking, typically that has only been a concern for debt collectors and not original creditors, which would be credit unions, because the FDCPA would typically only apply to original creditors, or I'm sorry, would typically only apply to debt collectors and not original creditors. But as we can see by the Pennsylvania Attorney General, this action illustrates that they're not going to shy away from using Pennsylvania's consumer protection laws to enforce a general public policy against forum shopping. So it's going to be really important for credit unions to review their policies if they file their own lawsuits in magistrate courts, especially if that policy includes some sort of blanket policy to file at the magistrate down the street. It at least appears at this point that the Pennsylvania Attorney General is not going to allow that to fly here. Now, county courts are typically an entirely different animal. These courts are typically general jurisdiction, so there's no monetary limit on the dispute. Lawsuits can generally be filed in the county where the borrower resides or where the contract is actually formed or physically signed. So the same analysis that you have with magistrate courts, but this one you're dealing with counties, so at least it's a little larger area and a little more defined area. So there are plenty of benefits to the county court system as opposed to the magistrate court system. County court systems are usually more formal, which is not always a bad thing. If you think about formality, what it brings is an addition of time, but it also brings predictability and it brings structure to proceedings, which is not always bad. If you think about maybe the most unruly member you've attempted to collect against, I would imagine that a little more structure and a little more procedure would have been a welcome addition to that collection process. And that's essentially what you're getting with county courts here. Additionally, judgments that are entered at the county level are generally not subject to immediate appeals. There are some exceptions to this for Pennsylvania, like the arbitration division, but ultimately, judgment at the county level are not going to be subject to immediate appeals. Most notably, county courts also have generally more extensive execution options. With a judgment at the county level, you can move forward with bank garnishments as well as wage garnishments in some states. It's not allowed in PA, but it's usually allowed in most jurisdictions. I know Pennsylvania and South Carolina are not going to be able to wage garnish, but most other states, you're going to be able to go ahead and garnish those wages, subject to some limitations that vary state by state, that generally deal with how much of the consumer's take-home pay that you can attach. Personal property can also be levied, and we'll get into the specifics of that later. You can schedule depositions in aid of execution, and you can also use the court system through motions to compel and motions for sanctions to make sure that the consumer is giving the credit union all the information that they're entitled to as a judgment creditor. So you can ask where assets are, you can ask to identify bank accounts, and things like that to continue to leverage the judgment to secure future payments. County courts do have their own drawbacks. They typically have higher costs. That includes costs of serving the defendant. The sheriff may have to make multiple attempts to effectuate service on the defendant. They also have tighter evidentiary standards. So you may be required to provide a witness to authenticate the documents that are going to be required to receive a favorable judgment. That just adds another time and complication element there. Additionally, cases at the county level can take significantly longer than cases at the magistrate level. It's not unusual for cases at the county to drag on for a year or even more. I have one right now that's been pending since early 2019, and I don't see any end in sight there, and that's a little bit on the longer side, but it's also not unheard of. County courts are also dealing with this COVID-19 pandemic by transitioning to largely virtual hearings and avoiding in-person contact. While this does offer some convenience, it again removes a situation where you have face-to-face contact with the defendant and removes the potential opportunity to discuss a settlement. Additionally, and maybe more problematically, there's no uniform approach that these jurisdictions have taken to these virtual hearings. So each jurisdiction has its own policies that they're basically just making up on their own as they go along. So you have questions that are like, how do you introduce evidence if the hearing is being conducted over the phone? How do you cross-examine a defendant over a teleconference if they don't have the documents in front of them? Does the court have a good email for you to ensure that you get notice of any Zoom or video conferencing hearing that's scheduled? All of these things are just layers of complication that these courts haven't quite figured out yet, and they're all coming to different answers for. So that just adds another layer of complication when you're deciding how to move forward here. Because like we discussed before, courts are probably going to keep this structure going forward. They've seen the same positives that other industries have seen from the work from home model. So I expect virtual hearings, especially at the county level, to continue just because they've seen the success that it can have in clearing their dockets and making it easier for them to deal with. Obviously not easier for us to deal with, but they're not necessarily too concerned about that. So because this is probably going to stick around, it's going to be increasingly important to track each jurisdiction's procedures and the requirements that they have for these virtual hearings, and use that as an additional factor with how to decide moving forward whether or not you're going to file in the county. Oh, sorry, I missed a slide. We can go on to the next one as well. Once the judgment is entered and there's no settlement or payment arrangement agreed to, it may be necessary to execute on the judgment. In Pennsylvania, you're going to want to make sure that that judgment before execution is less than 21 years old. Depending on your jurisdiction, you may have longer, you may have shorter. So you're going to really want to make sure that you check your jurisdiction's rules about judgments and make sure that your judgment's good before you execute. They'll typically run from between 10 years all the way up to potentially 26 years, but you just want to be aware of that as you're attempting to execute. Now, what sort of execution works best is going to come down to, again, the overall goals of the credit union and their risk assessment on the file. If the judgment is at the county level, you can garnish a consumer's bank account and essentially freeze all money coming out of that account. Money can still come in, but nothing's going to come out. So when that consumer pulls up at a gas station to try to put gas in their tank, that debit card is going to be declined. They're going to have to call their bank to see why, and they're going to find there's a bank attachment as a result of this judgment. And I have to imagine that's going to instigate a call to the credit union to try to get that resolved. It's important to note that many funds, especially government benefits, are exempt from this sort of attachment. And that includes unemployment benefits, pensions, Social Security, and some other government fund benefits that are not going to be subject to an exemption. But that's a claim that the consumer is going to have to make in the course of an execution action. So you don't necessarily need to be aware of each and every exemption that's going to be applicable in your state. Just be aware that there are exemptions, and if the consumer raises one or more of them at the time of execution, you can deal with that issue at that time. Wage garnishments can also be effective if that's available to you. So if you are in a state that's not Pennsylvania and you want to try to attach wages, you're probably going to be in luck there. Like I said, subject to some limitations in terms of how much of the take-home pay can be garnished. That can be an effective way to ensure recovery for the credit union. Personal properties can also be useful. These aren't so useful in terms of recovering on the judgment because most personal property just doesn't have any real value. But it could lead to potential contact from the defendant and future payments, just because most people are particularly attached to their things. So if you send a constable down to somebody's house and tag their TV to sell, chances are you're going to be getting a call from that consumer pretty quickly to try to prevent that sale from going forward. Finally is the judgment lien. This is definitely the easiest method to execute on a judgment because it's essentially entirely passive. The lien created by the judgment is going to impair the consumer's ability to essentially do anything with real estate in the jurisdiction where the judgment is entered. So they're not going to be able to sell the real estate. They're not going to be able to refinance the real estate. So if they're looking to remodel their bathroom or something and they go in to get a refinance loan, the bank's going to find this judgment and it's going to throw a wrench into that process, and that judgment's going to have to be addressed before any kind of closing date comes up. So again, it comes back to leveraging the judgment into future payments for the credit union. The last couple things I have to discuss here are cease and desist letters as well as debt settlement companies. Just to give you an idea of what these are and how to effectively handle, especially the debt settlement companies. And with cease and desist letters, when a consumer engages a debt settlement company especially, the first thing you'll usually see is either a letter from the consumer or the debt settlement company saying that the credit union should contact the debt settlement company instead of the consumer. So obviously when you receive this sort of cease and desist letter, you should stop contacting the consumer directly and essentially follow what the letter says. If you're gonna deal with somebody for a settlement, deal with the debt settlement company unless you're advised otherwise by the consumer. And if you are advised otherwise, it's probably best to get that in writing, so you just have that for your records. It's important to remember that cease and desist is actually only related to contacting the consumer. It doesn't prevent you from filing a judgment against the consumer or otherwise moving forward with the litigation process. So if you get a cease and desist letter, there's really no reason to hold on the litigation indefinitely just because a debt settlement company has been brought in and they've told you to stop communicating with their client. So continue those litigation efforts, but also see if you can resolve with the debt settlement company, because ultimately that's what they're trying to do. So for those who may not be familiar with debt settlement companies, they are a little bit of an odd animal. So just having a good understanding of who they are and how they operate is important. Essentially what they do is they take payments from the borrower, and after taking out their fee, which is usually based on a percentage of the debt forgiven or the work that they do on the account, they pool the debtor's money together and attempt to resolve the consumer's debts one at a time with each individual creditor. So they essentially operate as a payment clearinghouse for the consumer. If they don't want to keep track of all their debts and associated settlements, a debt settlement company is going to do that for them, but it's going to come at a price. It's also important to note that there is absolutely no requirement to settle an account for a reduced amount, or really otherwise accept any offer that's being made by a debt settlement company. And in general, it's probably best to view a debt settlement company's first offer with some skepticism. With that in mind, though, you should be aware that the way these debt settlement companies operate, there are a bunch of debts for the consumer, and they either take a top-down or bottom-up approach in terms of the priority of the creditor for repayment. So if you turn down an offer, the debt settlement company is just going to go to the next debt and take that money and offer it to them. So declining an offer may end up putting you down in the list of priorities and could delay recovery. So that's something to consider when negotiating with them. Ultimately, I see an indication that a debt settlement company has been entertained as an immediate answer to the collectability element. So that's something that you're really going to want to look for, because if the consumer's paying a debt settlement company, obviously there's disposable income there, and there should be something available for payment. So that a debt settlement company is going to answer that collectability element. So you're going to be able to collect on this at some point. It's just going to be a matter of getting to a settlement with the debt settlement company. And that's all I have for you today. We've covered a lot of ground and we've touched on a lot of different topics. If you have any questions, feel free to reach out at the information that's on your screen here. I'll work to address any additional issues that may not have been addressed in enough depth. And if we have a bunch of questions, like Matt said, maybe we can set up more of these and address those larger issues one at a time in a future presentation.
All right, thanks, Matt. Good information. Appreciate it. Just like, I have a couple comments, and we'll go through a couple quick questions here before we turn over to Michelle. So what I will tell you is, filing the lawsuit, enhancing collections through the legal process works. We have been pretty active with filing. I mean, this is currently what is sitting on my desk, a big giant stack of lawsuits that are going to go out. We had a batch that went out recently. My telephone was ringing off the hook yesterday. People are flush with cash. They want to pay. They may have not wanted to speak to anybody, but you know what? That gets their attention. It works. That's what we really specialize in. Obviously, Matt's in courts all across Pennsylvania dealing with all sorts of issues. It really is an effective method to proceed. Matt talked about the virtual hearings. I will tell you, at the county court level, there will always be virtual hearings from here until the end of time. These judges, instead of having just to take Fridays off, they love working from home. That's not going away. Allegheny County, those judges haven't been in the building in over a year now, and they're not coming back. So it is what it is. And then last but not least, the cease and desists and the settlement companies, these debt settlement companies, your members are with them, they're using them. If you get that cease and desist, don't let it stop you in your tracks. I would strongly encourage that you immediately get it to someone like us, and we can file a lawsuit, because that's the way you're going to get to the front of the line. They have creditor escalation departments, they call them, which means that their customer's been sued, your member's been sued. they're going to find the way to pay you. Now, it might be it's going to be a settlement, and it might be, overpayments, but you know what? We're going to get a judgment secured on it. A lot of benefits as far as that goes. So let's go through some of the questions here real quick that Matt that you had, and I'll try to answer them. You can chime in as well as needed. So we had one, if an account is charged off and the $5 share is there, and the credit union transfers it into their members, to basically write a set off into the loan, does that count for the statute of limitations purposes? And the answer is no. Matt, as you said, it's a voluntary payment. So the examples I always give folks are, I tell the credit unions, if you're offsetting the member's account, that doesn't count because that's not voluntary. Even though it's in the agreement and there's a right of offset, all that kind of stuff, it's not voluntary. They didn't say, yeah, go ahead and transfer it. If they did, well, that might be a voluntary payment. The other aspect is, sale of a repo. You repo the car and you sell it. The deficiency, when you're calculating a deficiency, when you can sue on that. The sale of the car at the auction does not count. That's not a voluntary payment. That's been litigated before. So you're going back to all the way back when they made their actual last payment on the account. When they came into your branch and the member said, hey, make a payment. However they made their payments, that would be when you're running into the statute of limitations. So that's the answer to that question. The next question is, this is regarding the venue situation that Matt talked about with the Northwest Savings Bank consent decree, with e-signing. How do you consider e-signing? Is it, where is the document being signed? Matt and I actually kind of talked about this a little this morning about it, because it's an interesting question. Are you in a situation where you are, is it considered in your particular branch? I would say the answer is probably going to be, you're probably going to be stuck wherever the member lives, because in an FDCPA situation, which me as a debt collector, Matt as a debt collector is in, these issues have been pretty hot, and it's always been, you got to go where your member's at. It's more convenient for them. So if you're in, if your branch is in, if your main branch where you do your loans is in Erie, and your members in Meadville, and you did e-signing through, the e-signing, they signed it in Meadville. You signed it in Erie. It's a question. It's not set in stone or anything like that. Those are unfortunately what us lawyers argue about in court, and probably why we'll never go away to much of people's chagrin. But that's a challenge. So the reason why we put that information in there about the Northwest matter is, I know a lot of people file, where the credit union's at. This was really the first time anyone in Pennsylvania to an original creditor has made this an issue, raising the issue. It's always been an issue for us as debt collectors. And obviously, it's easier for us to file. We file everywhere and things like that. It's not a problem for us. So we're used to doing it. So just be careful. That's sort of the warning. I would encourage you, if you have any other questions about that, certainly give us a call. We can really sort of get in depth about it, because it certainly is more of a hot topic, especially with that consent order coming out, and with Attorney General Shapiro getting reelected for another 4 years. So they're going to be out there. They're going to be looking for examples to protect the poor consumer, to protect your poor member. So just beware as far as that goes. And then last but not least, we had a question on personal property. Question says, we have a motorcycle loan with a member. They refuse to pay and repo not working, because obviously the motorcycle could be hidden anywhere, which is true. A judgment's entered and an information subpoena is done, but they don't disclose the motorcycle. They still have. Can we still consider this personal property and have the sheriff try to levy it? Yeah, I mean, it's always personal property. You have a judgment. Your judgment should be for possession and money if you're doing a replevin. So your judgment's like any other regular judgment. You can attach personal property. Now, obviously, you've gotten possession of the motorcycle legally, and you want to get in a position where you're going to be able to, get possession of it through the normal process, with petitions to deliver and petitions to break, and there's all sorts of crazy stuff that we can do. But yeah, I mean, you can have the sheriff go and do a personal property levy. That is personal property. Same thing with like a car and things like that. Obviously, there's liens when you get cars and different things of that nature. But yeah, so those are things that are certainly out there. So that appears to be, and whoever asked that question, if you want some more detail on it, give us a call. We can talk to you about it and sort of talk through it. So with that being said, Matt, I don't see any more questions. Nice job. We appreciate it. Certainly, it's a lot of information, a lot of very good, basic, solid foundations and fundamentals to remember. But there's so much more that's out there that exists. But again, thank you very much, and we'll go ahead and move forward with our foreclosure section here.
Thanks, everybody.
And there's Michelle. So
Good morning.
we will go ahead and move into our next section of the presentation here, navigating the world of foreclosures. And you have the perfect person to do it. She's on the front line. She's getting all the questions, dealing with all the courts, up to date on all the moving targets and regulations, and God only knows what else is going on. I can't even keep track of it, and that's why Michelle's around, because she does a great job of it, and she'll take it from here. Michelle?
Thanks, Matt. Everyone, nice to see you again. Let's dive into the world of foreclosure. And actually, I wanted to say into real estate in general. I love real estate, and I think most people do, because it's something that whether you're in default or you're not, you touch upon it. You touch upon it in your daily life. We all have places to live and mortgages, and we've all started from something. And I deal with it a lot in my personal life. So there's a lot of information I have kind of stored up here that we might not do in the office, but you might have a question and say, hey, this doesn't seem right or something. Please reach out, let me know, because there's things that I've dealt with, again, on commercial sides, landlord, tenant, all sorts of things that I think we all see on a daily basis, aside from just our daily job. So let's dive in. Can we have the next screen, please? Okay, so how I want to start here is some of the current COVID-19 regulations, and COVID hit us hard on so many levels. Right now, Fannie Mae, Freddie Mac, we have moratoriums through June 30th. Is that going to change? I don't know. I couldn't tell you. It seemed to change weekly at different points. So we just try to stay abreast of what's going on and keep that moving forward. I think for most of our clients, though, at least for the credit unions, we have been lucky to be able to continue on, and that has been great, to just keep the ball moving on these. With single family homeowners, with the FHA insured mortgages, the moratorium on those, again, June 30th. Now, these are excluding the vacant or abandoned properties. A lot of times I say, go out and check. If you have a department or a group or a vendor that can go check, go see if they're vacant, go see if they're abandoned. Some people know that they've been in a predicament financially and they bail. And frankly, it's sometimes the best thing that can happen, as long as you know, and then we can get that situation taken care of. Now, these also include eviction and ejectment matters. So all of the Fannie Mae, Freddie Mac, FHA, those include eviction and ejectment matters. Those loans can't do anything. Eviction, and one thing I want to touch upon here briefly, the difference with eviction and ejectment, and some people use that term interchangeably, and it's not. So ejectment is probably what we see more on a daily basis with our files. We get to share a sale, and we have a tenant or a homeowner borrower who is staying in the property. The tenant, obviously, because they might not even know what's going on, and the homeowner just because they're dragging their feet and they don't want to get out. So you have to file an ejectment action to get them out. Now, the nice thing with ejectment is that they do not follow the exact same guidelines and procedures that the evictions do. So, you know, I get a lot of questions. They're like, Michelle, we have somebody squatting in the property and the bar, and they're not leaving, and we want to get them out. Well, let's file an ejectment. We can, because they're not there. They're not paying because of COVID. It's not a rental issue. Whereas in the evictions, for a landlord-tenant issue, you can't evict somebody right now with COVID because they're not paying rent. And that's the difference. Now, you can evict them if they are out of contract, not rent-wise, but you know, let's say they're doing illicit, illegal activity. You can evict them if you're a landlord-tenant. Same with ejectment. If the contract's up, you know, let's say it was a 12-month, that ended a couple months ago, you can evict them. Now, that being said, the courts, different communities, they might make you jump through some hoops, but you're not going to get dinged for moving forward on those. So those are some matters I wanted to bring up. Can you bring the next slide, please? Okay, so moving forward with the foreclosure, and I'm kind of throwing this out of sync a little bit because I want to touch upon and make sure we touch upon things that are important with COVID and what I've seen that pertain to more of our loans and more of your loans than just going through the standard of like, well, what's a foreclosure? We'll get to that, but I want to hit on the important things first. And one of those is the extended holds and judgments and reassessing damages. And I'm sure many of you I've talked to about this, you know, they'll like, Michelle, we have a loan. Obviously it's been on hold from COVID for a year, maybe longer. They were on bankruptcy, then it got off, then it was on COVID. We've paid the taxes on it. We've done additional legwork on it. You know, we have $10,000, $12,000 more that's owed on it. What do? We already have a judgment from before. So in Pennsylvania, as many of you are aware, you can't just add that on and continue on with sale when that comes. You have to reassess the damages. And that's done through a motion through the court. Again, some courts, they're quick. You know, you can get those actions and orders 30 days. Some are upwards of 90 days. But depending on the property, and you might know this better than I do, what that equity looks like in that property. You know, if you're sitting on a loan for $100,000 and the property is worth $200,000, $250,000, and you have another $12,000, $15,000 due from taxes and stuff, it's worth taking the time to file the motion, even if it might push out the sale date, to reassess those. Because when it comes time for sale, we can only take the judgment amount. So if you don't have that for the judgment amount and a third party comes in and only pays 100 and you really need 115 to kind of clear your plate, you're already down. So it's worth doing that. I tell all of our clients. Now, if it's only 1,000 or two, it might not be worth it. It might be better to let's get it. Or if it's a problem borrower, a problem property, we know what those mean. And sometimes it might not be worth reassessing and just let's get this moving and keep that ball running while we have some steam. Because you could get tied up in litigation then, obviously, if the borrower wants to go against the motion, they can, and that can tie you up too. So you have to kind of gauge where that property is and that borrower and how that might play out. And I've seen it both ways, and I'm sure many of you have too. So that's something to pay attention to. Another thing that's coming up a lot with extra interest is the ACT notices, those ACT notices. And mostly because of the expiration. People always ask like, well, what's the expiration? Generally speaking, ACT notices do not expire per se on an amount of time. It's not like, oh, well, 6 months has come and they expire on that 6 months one day. Doesn't work that way. They do, however, become stale and new ones are required at certain times. And there's some tidbits on how that comes about and what I always recommend. Can we have a next slide, please? So ACT notices are required for each new foreclosure action started on the loan. So I give an example. The sheriff's sale is scheduled and borrower brings the loan current. The action is dismissed. We see this often. Sheriff's sale scheduled, they bring it current, they make some payments. 9 months later, borrower is 90 days delinquent. And then I get the question, well, we sent an act notice. Do we need to send another one? Yes. Yes, we do. We must send a new act notice because it was scheduled, it was dismissed, a new action would need to be filed, a new act notice would need to be sent. And I recommend sending the new act notices if the act notice was sent but foreclosure was not started as well. So, you know, same thing. If it was put into play and then it wasn't started, let's send another one. Another example. The act notice was sent in 2019, but we never filed suit and the borrower started making payments. We see this again all the time. We send out that act notice, you know, they're 90 days delinquent. We send out that act notice and the borrower's like, oh my, I didn't realize I was that far delinquent. And they start making payments. Okay, great. And then, you know, maybe the borrower didn't come completely up to date, or maybe there's some other things that came into play, COVID-19, things like that. And then it becomes to where they're 90 days delinquent again. And I get asked all the time, Shell, well, we sent that act notice, we didn't file suit, can we still use that act notice? And my answer is always the same, it's not a good idea. And reason being, you run into the situation where if you use it and it is contested, it can create a plethora of problems. So for the 33 days that it takes to send it, for the expiration of that act notice, send out a new one. If you're questioning it, send out a new one. Because you don't want to get into that situation. And especially right now, courts and all that, they're being defendant tenant friendly. So you don't put that into the court to make a decision. Just make it for yourself. You know, if there's a question on it, let's send a new act notice. That way there's not a problem. Can we get the next slide, please? Okay, and this is what I touched upon a little bit ago. The ejectments are allowed during the COVID-19, but they can't be due to unpaid rent. Now, as I said, ejectment and evictions are different, but with an ejectment action though, you do have the opportunity, let's say before you get started on an ejectment and we file a sheriff's sale, we get through sheriff's sale and you guys are deeded property, you own the property, and there's a tenant in the property. You have the option of allowing the tenant, if let's say they have been making payments, to continue to make payments to you now instead. So those are some options to look at, but you don't have to hold them in the property. It just depends. Another thing I see often is, in a lot of questions, is with personal property. Items left in the property after the foreclosure or after ejectment. Like I said, some people just bail and they leave their stuff. I don't know why, but it happens. So with that, we need to send a letter to the borrower or the occupant or the tenant providing a 30-day notice to obtain or make arrangements for them to collect the personal property. Now, a lot of people are like, well, it's been 30 days, I'm done. I heard from them, they called, but I didn't really get to talk to them. Like, what do I do with it? Again, courts, they're defendant tenant friendly. So make a very diligent attempt that if we send out the letter and 30 days and let's say 15 days in, the borrower or tenant is trying to reach you and you guys are playing phone tag or something, don't dispose of their property. Keep it in a secured place. The law requires that you keep personal property in a secured place for 30 days. That secure place does not have to be the real estate. You can put it in a pod, storage unit, wherever you want. You're allowed to keep moving with your property, but you have to secure their stuff. Because if it comes back after 30 days and you dispose of their belongings and they go to court and they're like, wait a minute, you know, and they could file something themselves, pro se, you know, that was my great grandmother's quilt that was in there and it had sentimental meaning and I was trying to get in touch with you. And you know, we see that stuff all the time. keep it secure. Do the best you can to get in touch with folks if they reach out to you. Now, if you send a letter and it's ghost, you can dispose of that property then at that point at your leisure. But you have to give the 30-day notice. Another thing we see coming in, like I said, I'm kind of bouncing a little bit right now, but I want to touch on these important things that's come up more so. So another thing that I see are utilities and other real estate bills, and we've had some clients reach out about these things. So when the borrowers and occupants quit paying utilities, and I've dealt with this on my own personal properties time and time again. So let's put this in perspective. We have a property we own, went through sheriff's sale, we're deeded, great. And we have an occupant in there, whether it's, let's say it's a tenant. And we filed the ejectment action, and they're litigating it. I have one of these currently going on, and they're litigating it. And it's being held up in the courts because the courts right now are slow. Some of the courts are slow getting stuff, between COVID and getting stuff scheduled, they're slow, backed up, and can't get them out because you're in the middle of litigation. Well, in that time, that tenant has quit paying the utilities. Of course they have, right? What do? We have clients who are getting hit with some massive, massive utility bills, and water is one of them. That's why I put that on there. The owner, whoever that owner is, so if it's you after the sheriff's deed, or you are responsible for that bill. The water bill mostly is lienable. It follows the property. So if the tenant decides to quit paying the water, you can try to go after them in small claims, magistrate level, usually unsuccessful. But you have to keep paying it, because it will then be a lien on the property that when you come and get the person out and you go to resell it, you have to pay it anyways. You won't have clear title if you don't. And there's really no way to get around that. Now, other utilities do not follow the property. So, a tenant puts cable or phone line or something, you're not required to pay for that. That's on them. That's that. Electricity, that's a tricky one. Electricity usually does not follow the property. It's usually put in with the tenant's name. If it is required to go in with the owner's name, then it would follow the property. Now, some questions we get is, well, why can't I just turn off the water or turn off the electricity? I mean, I'm not paying it. They're not paying it. I don't want to have to pay it. Then it becomes frowned upon, where you might run into where, like, the health and safety, like those things. And that's getting out of the realm of foreclosure and real estate. And you're starting to get into like general habitability and things of that nature with municipalities, the state, and entities that are larger than we are, that we probably don't want to touch upon. It's just a really sticky situation. And I have litigated this in the magistrate level, the common pleas level. I have taken them on my own personal properties, and it's the nature of the beast, unfortunately. So it's something you have to watch for. Can we get the next slide, please? Now we're going to dive into the basic foreclosure procedures. Like I said earlier, we talked a bit about the act notice. It is the state mandated document, and it must be sent out to all borrowers prior to an action being commenced. That notice requirement must be on loans that are 90 days delinquent, and borrowers are given 33 days from mailing to attempt help from HEMAP. Usually once they send out for HEMAP, if they ask for help, we are all notified, and we immediately have to put a hold. We have to stop action, stop procedures. I don't see that very often anymore. I don't see a lot of requests from HEMAP, and I think maybe because they're so far. So HEMAP has some regulations, and you can only be so far behind, so much debt needs to be owed to bring it current. There are certain ramifications with HEMAP. So I haven't been seeing those as often, but nevertheless, it's out there and it's something you need to be aware of. Can we have the next slide, please? So now we're going to move on to the complaint. So act notice has expired, no HEMAP, we're good, let's keep going. So complaints, they're filed in the county the property is located. So I think we talked a little bit, or Matt talked a little bit about that in the last segment of, where things are in jurisdiction. For foreclosure, it's where the property is located, not where it's signed, anything like that, not where the borrower lives. It's where the property is located. And in the complaints, we need to include the executed note, the mortgage, act notices, and verification. All of the complaints, whether it's a regular complaint, amended complaint, any of that needs to have a signed verification from the client. So we send those out and you'll see those. So those have to be included as an exhibit. Parties named in the complaint, they must include the borrowers, deeded owners, and the United States of America if there is a federal lien on title. And we kind of can get to that in a little bit. I've seen some borrowers and homeowners try, and I think people do it intentionally. They try to get creative in how they deed, mortgage, all of that, I think, to put liability on somebody else to get out of situations of having to pay. And I've been in court over it. I've had preliminary objections filed on it, and we continue to say the same thing, and so have the courts. If you have an interest in the property, some way, shape, or form, as an owner, a mortgager, deed, whatever, you're going to be named. Okay, you're going to be named. It's just the way it is. We've had where folks, have passed away, COVID, maybe, whatever other reasons, and we list an heir. We list a known heir. They may have no interest. Some people have, like, I haven't talked to my mom or dad or, whatever in a long time. That doesn't matter. You still may have an interest if there's not an estate open. You're going to be named. And, folks will say, well, I'm a deeded owner, but I didn't sign the note. I only signed the mortgage. I shouldn't be responsible. I'm not going to be held responsible. Again, they've had counsel file. I've gone to the Court of Appeals over this. If you're a deeded owner and if you have signed a note, mortgage, anything, you are going to be included. You have an interest. It doesn't negate that, oh, I didn't sign it. So it just, property is mine, free and clear. It doesn't work that way. Also, one thing that I have seen in this is with folks passing away, and it's not on my layout, but something that just come about, I want to say in the last maybe even 10 days, somebody has reached out and asked, parents, grandparents, they're passing away, unfortunately, because of COVID and different things. And they were up to date. They've been up to date on the loans. And maybe now a child wants to take over that mortgage and they want to keep the property. Maybe parents had a good rate, paid it down, there's equity, whatever. Clients are worried, well, what if they just deed it over and what happens to our interest? If we have a mortgage and it is recorded and they want to do a quitclaim deed or something like that, that does not nullify the mortgage. That mortgage is still owed. So whoever takes that property, you're taking it at your own risk, so to speak, because the mortgage is still owed and they can continue making payments on it. Now, there are some documents that you can get to take over the mortgage and some of that sort of thing, but it doesn't just make the mortgage go away. They can't just, oh, well, they died and so it just washes. It doesn't work that way. So not to worry about that. The complaint, once it is filed with the prothonotary, is only good for 30 days. And it's one thing I want to touch upon. And it has to be served by the sheriff or a process server in that 30 days. So in other states, once you file the complaint, some of them are open for 6 months, things like that, that it's a healthy complaint. In Pennsylvania, it's only 30 days. It's very limited time to get a complaint to somebody, especially if they know it's coming and they want to dodge service. We see it all the time. So then what we have to do is we have to reinstate the complaint with the prothonotary, have it stamped again, and then attempt service with the sheriff or a process server if it's in Philadelphia County or outside of state. And so there's some tricks there that, and hurdles more so, that if somebody knows it's coming, they're going to have to, they're going to try to stall on that. Can we have the next slide, please? And so this rolls into the service of the complaint. Like I said, service of the complaint must be made by personal service by a sheriff to all parties named as a defendant, except the USA, which we usually have a stipulation executed in that situation. But all our defendants must be served by the sheriff, except, like I said, Philadelphia County and out-of-state defendants are able to be served by a process server, and we utilize those. Now, some sheriff's offices, they'll attempt it 3 times and that's it. Some will attempt it 12 times, 15 times. They'll just keep on going. I've seen different counties. I want to say recently Westmoreland, they would attempt it 3 times. That was it. I'm like, the complaint's still good for another 15 days. All right, 3 times, that's it. So then I have to send in a new instruction sheet on it. Whereas Dauphin County, I want to say it was Dauphin County, I had a sheriff return and they had literally, I want to say like 14 different attempts. And again, the person was dodging service. They would be in there cooking dinner and the sheriff would just be knocking. Nobody would answer. You can't do anything. The sheriff can't barge in. They were dodging it. So, it depends on the county of how that's going to work. If there is no service, if we cannot serve a party after multiple attempts, or we cannot locate a party, somebody has moved in that time frame, we do an accurate search, we get new addresses, we continue to attempt it, and we just can't locate the person, or they have a PO box and that's it, you can't serve PO box. We motion the court at that point for an order allowing alternate service. It's called the motion for alternate service. And one thing I want to point out is once we attempt service, let's say we attempt it in the first attempt 30 days and we don't get service, but the sheriff returned, they tried it 4 or 5 times and they put in the notes. Sheriffs will oftentimes in their affidavit put in notes. No service, car in the driveway, or person wouldn't answer the door. Looks like movement in the house, or there was a minor in the house, can't serve a minor, no service. Well, that doesn't just automatically mean we can do a motion for alternate service. I wish it did. The courts usually will deny that. They again, they're defendant friendly. They will make you push to do everything you can to get regular service through the sheriff. They're not going to allow motions where we can just, in order, send it by certified regular mail and post the property. Especially if there's stuff in the sheriff affidavit saying, no, we couldn't serve them, but we think there's people there. So we use the motion for alternate service often, but it's not just a given that, 30 days and we can use it. It doesn't work that way. And especially right now, again, courts, they're pretty strict on things in that nature where they want you to attempt to get service. Now, let's say we've done everything, we've done our due diligence and we've attempted it and the property's vacant or nobody's been there in a while and addresses are coming up, but the sheriff returns saying nobody's there. Then we'd use the motion for alternate service and it's usually pretty successful. We're able to get that motion in that order at that point, but there has to be some attempts made. Once the complaint is served, so let's say we're good, we continue on and we're able to get that sheriff to hand those papers over. Once the complaint is served, the parties that were served have 30 days to file a response to the complaint with the court. Now they can file an answer, preliminary objection, so forth. Can we have the next screen, please? But once they are served, they have those 30 days to get a response filed with the court. After those 30 days, that's when the expiration of the answer period of the complaint happens. Now, oftentimes, defendants will get a complaint, and maybe they're trying to get counsel or something like that, and past that 30 days, counsel, they obtain an attorney and counsel files a response. Or maybe even they do it pro se. Usually the court will accept that response and then allow for the defendant to litigate the foreclosure action. It doesn't just, if they're late, oh, well, you were late, we're going to go on for a default. Courts, again, they're friendly that way to the defendant. So even if it's late, it's going to then be deemed a contested foreclosure. But that's a whole nother issue. Let's move on as if 30 days expire and there is no filing of anything by an attorney or pro se by the borrower. So then we send out the 10-day notices. This is a requirement that must be sent to all defendants at least 10 days before you can file for the default judgment. This is just kind of a notice of like, hey, we're getting ready to take a default, do or die, do something. If you want to file a response, file something. But it is required. And then once that 10-day notice expires and that 30 days has expired, then we can file the default judgment. And we press a P for the default judgment and request the court to grant the judgment by default. And in that default, that press a P for default judgment, we have to include those 10-day notices. So, if you forget to send the 10-day notice, or something haphazardly it's missed, you have to send them again. In the courts, prothonotary especially, they're tricky. So if you're on that 9th, 10th day cusp and you try to file the default, they'll reject it. They'll reject it and they'll say, the 10 days hasn't expired yet, till that very end of the day. So then you have to wait till the next day. So technically, I like to say it's the 11th day when you can file the judgment, because if it's still that 10th day and you file it at noon, they'll say they still have today. They still have the end of today to get something filed. So I've seen that before. So we always technically wait till the 11th day just to prevent hiccups. Can we have the next slide, please? So we have the judgment. Now we're going to move on to the writ of execution. This document, it seems a lot of people think like, oh, it's just scheduling the sheriff's sale. It's a big document, I think, almost more so than the complaint stage. I think the writ stage, it kind of rolls into the sheriff's sale stage, and it's a big deal. And what it is, it's asking the court to allow the sheriff to then schedule a sale. And once that writ is once the writ of execution is filed with the court, it's then submitted to the sheriff's office of the county the property is located to get that sale scheduled. And unbeknownst to me, I can't figure out why, but the prothonotary in the sheriff's office, I know they're two separate entities, but working hand in hand with each, they do not. In each county, they have their own nuances as to what is required in the writ of execution document, in the packet. The prothonotary might accept one thing and the sheriff's office will accept another. And I've seen it often, and it's created problems and delays in getting them scheduled. So a sheriff's office will have a sheriff's sale date, and then they have what's called a last day to file. So you have a last day to get your writ filed with the prothonotary and in the sheriff's office. Allegheny County is one, and they are very diligent, I'm going to use that word, in making sure everything is exactly how they want it. Sometimes to the point that it's not really necessary, but they require it anyway. So if we file the writ, we have the pleading, and we take it over to the prothonotary and we get it filed, and the prothonotary types it up, and it says known and unknown heirs of John D. Smith on our pleading, and that's how the documents are. But they type it in, known and unknown heirs of John Smith. They leave out that middle initial D. So whenever we take over the writ packet to the sheriff, after it's time stamped by the prothonotary, and we take it over to the sheriff's office and they're going through it, they will deny it. When they print out that writ of execution that was accepted by the prothonotary and they see that that middle initial is missing, that the prothonotary typed in, they will deny that writ packet. So then we have to go back over to the prothonotary and ask them to please update and correct the caption and things like that. So it just to know sheriff's offices are very, very particular. And what one might accept, one in one county, another will not. One county might want 10 copies of the 3129 notice, whereas another county might want just the original. Some, some want certain cover letters, others do not. Some want a waiver of watchman, others do not. So it's not a one size fits all with getting these scheduled. And that's why I put such an emphasis on the writ of execution being such an important factor in this, because it's not really held to a civil procedure tactic that like the complaint is run by the civil procedure, federal, state governments, things like that. The writ is not exactly. It's run by each sheriff's department, and sometimes by what I call the gatekeepers of those departments. They can say, oh, well, we'll accept this time, but next time, I want you to have 3 envelopes, not 2. They can make those kind of calls. So we have to watch for those. And with COVID, things have changed drastically in that they don't want people in their offices. So what we used to be able to go and have people go and personally hand in these documents to make sure they have everything that they want. Now they won't allow that. So you have to mail them, and they try to do as much non-touching with certain things as they can. Different notices they want put into the writ packet. The sheriff's office does that say, this sale's being handled during COVID, and there's all sorts of nuances that they want. So we have to watch for those. But alas, once it's taken, once it's accepted, the sheriff then sets those dates. And usually you can expect those dates to be scheduled several months in advance. Can we have the next screen, please? So yeah, like I said, once we get that writ filed, the sales are scheduled for several months in advance to allow for additional sales items to be completed. Anywhere from 2 to maybe 5 months out. And I know a lot of clients are like, we just got to this point. Why is it taking so long? A lot of those are just the dates. We have some counties that have a sale every month, and you can get your documents written in, and 2 months later you can get a sale. Some counties, some of the smaller counties, they may only have a sale 3 or 4 times a year. So you can expect that quarterly sale. So if you miss their file cutoff date because we're trying to get a judgment or something, you might not be able to make that next quarter sale. You might get the one after that, and that's 6 months down the road. So again, it's what that sheriff's office does. And if you don't have it filed by the date they want it filed by, maybe you're still in judgment stage or service stage, you're not getting that sale date. Once we do get the sheriff's sale scheduled, we request an updated title report to ensure new lien holders have not been added to title. And that's something that's really important right now, and I'm seeing with COVID, is let's say we had a sale scheduled prior to COVID, March 2020, and the sheriff's office has continued to postpone the sale. And then we decide, well, now we've paid taxes and we have more, and we've done a motion to reassess. So we're getting a new damage amount. And now we're moving forward to the new sale date. We got it. Let's say we have a sale scheduled in May. A lot of these, I am updating title, because if you miss something on that title or on that 3129 that was filed before the sale, and then you get the sale and something has come up, they could come back and say, well, we were never notified. We were never notified, and it can create a problem. And then you might have to try to divest a lien after the sale, and it can just become a hiccup. So if files have been on hold for an exuberant amount of time, I request an extra or an updated title report. But regardless of whether it's been on hold or not, once that writ is filed and we move on to the sheriff's sale, we get an updated title report to just ensure from the time of complaint filed to sale scheduled that there hasn't been anything else added. Also with the sheriff's sale, and a big thing we see is the notice of sale. It's a document, it's about 3 pages long in the writ of execution packet. And this is probably, of all the things in that sheriff's sale packet, this is probably one of the biggest steps. And reason being, it is just like the service of a complaint. That notice of sale is required to be served on all defendants by personal service by the sheriff. So, think back when you were at the sheriff or at the service stage of complaint, and you might have had headaches then, like, oh my gosh, trying to get that served. Well, if we had an order from the court from that service of complaint stage for the motion for alternate service, we can use that order to serve that notice of sale. So, let's say we had trouble back at complaint stage, we can use it to send certified regular mail posting, publication, whatever the judge signed off and required. We can use that at that notice of sale stage. But let's say we had good service at the complaint stage, so we never had to use a motion for alternate service. And now we get to the notice of sale, and again, maybe it's been on hold or something, and defendants, they left. They're like, I don't want the property, I owe more than it's worth, and they bounce. Well, now we can't serve them. We don't know where they're at, so we're doing accurate searches, or maybe they moved out of state. We have an accurate search and it says where they're at. Maybe they moved out of state, maybe they moved back in with their parents, maybe with a brother, sister, aunt, whatever. We have to get service on them by sheriff. So that might mean deputizing that county sheriff to then serve that borrower in another county. If a sheriff's sale is scheduled, let's say it's scheduled for May 25th and it's March 25th, and we're struggling to get service, and we're doing what we can, and we can't get service 30 days before that sheriff's sale. So let's say April 25th, and we still don't have service. That sale is required to be postponed. We have to postpone it. There's no ifs, ands, or buts about it. The rules, the civil rules and the state rules require that sale be postponed. So where hiccups come up at times is, if we get that writ filed and that sheriff's sale is scheduled 2-3 months out, and we get the notice of sale, we get the package to sheriff, and they're trying to obtain service and they can't, you have a very small window of time to try to get that motion for alternate service to the court to then get an order allowing for the alternate service to be completed within that 30-day realm of that sheriff's sale. So then usually we have to postpone that sheriff's sale for that matter. Now, sometimes, service is easy and we just continue on. And again, we run into a situation where it might be at the hands of the sheriff's office themselves. Maybe they'll attempt service 3 times, they send it back, we couldn't get service of the notice of sale. Then you have to send in a new instruction sheet because that's just what that sheriff's office requires. Again, Westmoreland County was one that has been pretty stickler on that, whereas other counties, they'll keep attempting service, for months and months if they have to, if the sheriff's sale is that far out from the writ filing. Can we have the next screen, please? So postponing or continuing the sheriff's sale, if we have to. The plaintiff can postpone the sale 2 times for up to 130 days with a notice of continued sale. This does not require a court order. After the 2 postponements or 130 days from the original sale date, an order court is required to postpone or continue a sale. If an order is not, or if an order is required and is not obtained timely, the sheriff's office will automatically stay or cancel the sale. You want to make sure that that does not happen if you can. And the motion to continue sale, it needs to be filed timely so the order is obtained. Can we get the next slide, please? So like I said, the sheriff's sale, we want to avoid this. If a sale has not been postponed and it is required to be stayed because you couldn't get an order in time, if it's last minute and we're not getting information to postpone it, or maybe there's a payment plan and we're trying to figure something out, if it's automatically stayed, in order to then get it scheduled again, you have to refile the writ. So that big long process of filing the writ of execution, getting the notice of sale, that will have to be done again if it is stayed. So I'm highlighting the importance of getting an order from the court timely to continue the sale versus staying the sale. Even if there's a payment plan on it, I always recommend clients don't stay the sale. Just keep postponing it. Pay the little bit to keep postponing it, because you're going to go through a much bigger headache if something happens in that time and you stay it versus just continuing it. Next slide, please. So after the sheriff's sale, the sheriff deed is recorded. This can take time. Again, it's up to the sheriff's department because they're the ones who are preparing the deed and recording. I tell people, don't be surprised if it's as quick as 30 days and as long as 3 months. It's up to the sheriff's office. And then the sheriff's office and the recorder have to kind of work together to make sure it's accepted and so forth. In that time period, from the date of the sheriff's sale to the time the deed is recorded, no activity or action can be taken on the property until the deed is recorded. So the buyer at the sheriff's sale is not deemed in Pennsylvania to own the property until the deed is recorded. So if there's any post-sale actions, if a sale can be challenged for different reasons, lien holder wasn't notified, whatever. A lot of them don't hold weight, but they still can become tedious in clearing them up. So people can file actions after sale. So that's why you're not deemed to own it till after. Next slide, please. So we're going to move on to ejectment actions. We're going to keep this pretty short because a lot of it is very similar to what you will find in your foreclosure actions, procedurally, that is. Again, I mentioned this earlier, the difference, ejectment versus evictions. Previous owners, tenant occupied, etc. There's a difference between those. If the property is vacant, an ejectment action does not need to take place. I get that asked to me often. If after sheriff's sale and the deed's done and the place is vacant and nobody's in there, there's no property, there's nothing, you don't need to do an ejectment. Go in, change the lock, move on your way. Get that property sold and get it off your books. You don't need to worry about anything. But if there is occupants, tenants, previous owners, whatever in there, the ejectment action cannot begin until the notice to leave is provided after the sheriff deed and sheriff sale is recorded. Like I said, Pennsylvania is tenant friendly. There are a lot of procedures that must be completed for the ejectment actions to proceed. Next slide, please. And that is the notice to leave and tenant letter must be done. It's similar. I like to put similarities on things, so when you think of it, you're like, oh, that kind of makes sense. It's similar to the act notice, not the same, HEMAP options, but it's required before the ejectment action can commence. A borrower, if the borrower is still in the property, they get a 30-day notice. If a tenant is in the property, they get a 90-day notice. Yes, 3 months, they get a notice. And if they're not paying bills or water, you're responsible for that, unfortunately. But they are allotted 90-day notices. Next slide, please. The complaint in ejectment, it is wholly similar to the complaint stage of a foreclosure. The defendants to be named, that is a little bit different. You must name the defendants as, if you know the tenant or you know the name, they must be added, and you must put the known and any occupants. So if you would have a squatter in the property, we don't know their name, you have to put them as any occupants. So it changes the defendant's name of the action, but if you know the person or in any occupants. Next slide, please. Service of complaint and ejectment. Again, similar to service in a foreclosure, all of the defendants, including any occupant, must be personally served by the sheriff. So how do you serve any occupant? Oftentimes the sheriff will just go, if they know a person, knock on the door, you know, here's the complaint. Any occupant, if a person's there, they're an occupant, they can take it. If not, if we can't get service, but it's being shown by vendors or whatever that it is occupied, again, we will do the motion for alternate service, which is exactly like it is seen in the foreclosure process. Now, one thing I have been asked, and I want to point this out real quick, you cannot use an order from a motion for alternate service from the previous foreclosure suit for your now ejectment suit. So, you know, let's say that borrower in foreclosure was being difficult, we had to get an order at that point, and they still want to squat in the property. That was a separate suit, separate action, separate case number. You cannot use that previous order to be used in the ejectment. So you have to do a whole new motion, whole new order, all of that. Next slide, please. So judgment and ejectment. Again, you know, I'm a broken record. It's exactly the same as it is in the foreclosure. You have to send out the 10-day notices. You have to then, after the 10-day, do the default judgment, and you can't file it within 30 days. You know, they get a time to respond to that 30 days. Next slide, please. Writ of possession. Again, similar to the writ of execution, we are asking the court and the sheriff to allow and schedule for the possession, the take back of the property. And this will be this document needs to be served on the defendant, similar to the notice of sale. And again, each county has their own nuances for the writ. Some require a motion hearing, some just filing the document. So you're kind of at the mercy of what each county and court and sheriff requires for that. But it, you know, a lot of people, and they're like, I don't understand. Like, my buddy, you know, they just got somebody out, you know, landlord, they just got somebody out. I understand why it's so difficult. Again, that's the difference between the eviction and the ejectment, and the reason you're getting somebody out in the documents and what's required at the court level versus the, or the magistrate level versus common pleas, etc. Next slide, please. So the lockout by the sheriff, once we get that writ of possession filed, and we're asking the court, okay, set us a time so we can take possession of that property and get the folks out who are still staying in the property. That sheriff sets the date, and then they give notice to the defendant. Again, it has to be served. At the time, once that lockout date occurs, the sheriff will lock the property and force any occupant out of the premises. They will force them to leave their belongings. They've had their opportunity. Now, that personal property that is left, if the sheriff has to forcefully remove somebody, again, that property must be secured for 30 days. You send out that personal property notice, and that personal property has to be secured for 30 days, giving them an opportunity to get that property back. And some matters to think about prior to and after lockout. And I've only had this come up a handful of times, but, you know, why wouldn't something random come up with these things? You know, we shouldn't be surprised. But I could call them hazards and dangers. One was animals on the property, and another were questions on weapons and things like that. One time a sheriff called me and they were like, hey, Shell, whenever this happens, you're going to need to call animal control or something, because there's like tons of dogs and animals, and, you know, I don't want to call it a farm, but, you know, stuff that needs to be taken care of, because then you get animal activists and stuff like that. So, things like that. Initially, I wouldn't even think of that, but those are things. Or if you're taking possession of a farm and there's farm animals. I mean, there's a lot of restrictions that are way over my head with different types of animals and animal control and all that, something to look at. And then another is the weapons. And again, I would like to say that I have the be all and end all knowledge on how to handle all that, but there's a lot that goes into it. And if that's the case, I would just recommend, getting in touch with the sheriff's office if when you go in and you're securing and you're finding weapons or questionable items in the property, get in touch with the local authorities and they will then help you get through that. You want to make sure that's being handled because I know there's like registrations and you just don't want to be the one having to make those executive decisions on things that could really become even illegal for that matter. So just something to watch for. That it wraps it up about the foreclosure and ejectment. I try to, like I said, tack on some things that I've seen lately, questions on. I've kind of jumped out of order a bit. So if you do have questions, please let me know. I'm happy to help as much as I can, but I wanted to get you guys the most pertinent information that we've seen in the last, let's say, well, oh my gosh, year. It's been a year.
Well, thanks a lot, Michelle. Great information. It's of course changing a lot and a lot to keep on top of. But there are a couple questions, so let's go ahead and go through them. I'll give them to you here. You were talking about personal property, at the ejectment at different stages. So conveniently, that was one of the first questions we had. Is the owner of the personal property responsible for payment of storage?
No. No.
Seems simple enough to me. Just another cost of doing business, huh?
It's the cost, yeah.
Along those lines, let me see here. When the owner is deceased and there is no estate or executor, do you still need to send a letter to the next of kin regarding property left at the residence?
Technically, I would say that is a case-by-case basis. If you know what, simple answer, I'm going to say yes, because then I would suggest that there's an occupant in the property. If that person is deceased and somebody is still in the property, a family member, a child, an adult child, put it that way, or something like that, then yes, they're still deemed an occupant. So if you were to proceed on with ejectment and all of that, they might have belongings in there, so they would have the opportunity to get those belongings. If the property is vacant and they left property and there's nobody, the estate's not doing anything, you hold it for 30 days, send out the notice to the property because you might not know who that next of kin is, and just mail the letter to the property address.
Makes sense. Sort of in a different direction, does a notice of intent, which I'm assuming probably maybe an act letter, have to get sent to all parties on the deed in addition to the debtor and the mortgage?
No, the act notice is only for the borrower. It only needs to go to the borrower, because if you think about it in a broader sense, you could have a property, let's say an investment property, to make it simple, with 15 owners, the 15 investment owners, but only one person holds the mortgage. Well, those deeded owners don't have the right to reaffirm loan modification. They're not on the loan, so they can't modify it. They can't apply for HEMAP or anything because they don't have the underlying loan. They don't have their names on it anywhere. The deeded owner is only responsible to be on the complaint, because if they want to secure their property as a deeded owner, they can bring the loan current. They can go out and get another loan and refinance, if you will, or pay off your loan or whatever. But in terms of an act notice, it's the borrower, because they're the only ones who have the right legally to modify, change terms, etc.
Okay. In terms of serving the complaint or ejecting a complaint for that matter, can a complaint be served at a place of employment? Now, of course, that's sort of a little out of our hands because the sheriff's serving it, and depending on where they're going to serve it. But what's your take on it?
Usually that's not going to happen because you are dealing with a sheriff's office and you have to attempt service where they reside. So it'd be in that county and at the home. I've never had a sheriff say that they would go serve somebody at their place of employment for a foreclosure action. Now, I'm sure in other kinds of actions, they do that all the time. But for foreclosure, I have not had a sheriff's office do that.
Right. I agree. I mean, everything's about the property.
Right. And I think you start running into FDCPA potentially because you're looking for an in rem action versus a personal, a personal action. So I think that's hairy, and I would shy away from doing that.
Sure. And the last question we have here is, thank you for mentioning death of the homeowners. What if heirs are not in a position financially to take on another obligation or initiate probate? What is the proper venue to legally pursue the foreclosure? The probate court or the county court? I mean, I would think if there's no estate, then, I mean, everything's going to be in the county court. They're the same courts, but in Pennsylvania at least.
Yes. If there's no estate, or let's say there even is an estate, you don't go through the estate. You still file the foreclosure action. You just name the estate if there's one known as a defendant. If there is not one known, and we don't know any of the heirs, we could name them as the known and unknown heirs of, John Smith or whoever that deceased borrower is. And we just proceed on with the foreclosure and we go on and serve it. And then, probably have to do a motion for alternate service, post the property. If there's heirs and they want to do something, they'll file a response. They'll get an attorney. They'll come due. They'll attempt to do something. But that's not your responsibility to open anything with probate at this point with foreclosure.
And one last question just popped in. If a spouse resides in the property, a divorce situation, is a spouse considered a borrower or a tenant in an injectment proceeding?
Okay, so we're asking about the spouse in an injectment.
Basically, somebody's in the property.
If somebody's in the property. So let's look at the ejectment and the foreclosure as two separate actions. If we foreclose and we get the sheriff's sale and we get the deed and there's a spouse in the property still who wasn't the borrower, they're an occupant. They're not deemed the borrower. They were never the borrower. If they were, they're deemed an occupant. We would proceed on as we would with any kind of ejectment action.
Okay. All right, that's it for questions. Certainly, again, it's a lot of materials in a short period of time. There's a lot of the devil's in the details, as it were. And if you have any additional questions, certainly feel free to ask. Let me know because, well, ask Michelle because I'm just going to ask her anyhow because she's the expert at it and she knows what she's talking about. So, Michelle, thanks a lot. A lot of great information. We appreciate it.
Absolutely. Have a good day, everyone.
And lo and behold, the last man standing, Gary. He is up to go ahead and give a quick rundown of what's going on in the bankruptcy world. So, Gary, without any further delay, go ahead and proceed.
Thanks, Matt, and good morning again, everybody. So, the way I'm going to run through here is going to try to weave in some of my experiences from the last year, which I think we can say across the collections world and foreclosure and bankruptcy and more. It's been a crazy year and we're still there. And then at the very end, I'm going to cover some legislation that is out there, might be out there, could be out there, and how do we think it's going to affect. So next slide. And next slide. So just to cover briefly, our footprint in the bankruptcy department here at Weltman, the states that you see there are states that we have an attorney in-house who is licensed. So if you send over a matter in one of those states debtors filed bankruptcy, it's going to be myself or one of my colleagues that is licensed in that jurisdiction that will be handling the matter for you. However, we are also able to file any matter nationally. So as I mentioned during my introduction, we are able to file proofs of claim or reafs or transfers of claim generally in any district in the country, whether it's in the 50 states, Guam, Puerto Rico, etc. If it is something that requires an attorney license to file in that district, so you're talking your motions for relief, your plan objections, your adversary cases, even if it's not one of those footprint states, we work seamlessly with our local counsel throughout the country, and we will get those filed for you. So if you ever have any issues in any state, feel free to reach out to me, and I always will work closely with local counsel in that jurisdiction to make sure everything's handled just as if I was handling it. Next slide. So quickly, I wanted to go over some bankruptcy statistics, and I'm sure you've experienced it already. We've had a massive decrease within the last year of filings. So for a frame of reference, if you look back to where our filings were more than 10 years ago, you'll see how we had a spike over 1.5 million per year in 2009. And if you remember back to then, what might have caused that? Well, that was when we had recession and we had housing crisis that led to bankruptcies. And so the next year you had that spike. Ever since then, we had started trending down. The economy improved, less people were filing. Then lo and behold, we get to basically February, March of last year, and COVID happened, and our decrease was even higher. So last year we had about a 230,000 filing decrease over 2019 when we didn't have COVID. Since then, it's continued to still decrease. In most jurisdictions, we are still seeing a decrease. Interestingly, when I reviewed the last statistics nationally and it broken out by district, one of the only districts that did not experience a decrease, not an increase, but was 0% decrease, was Western PA. I'm not sure why that is, but it wasn't a terrible surprise to me because in the last month to 2 months, there's felt like there's been a leveling off. So does it stay that way? It's hard to tell. And when I cover the legislation later on, we'll talk about what do we see in the future. And generally here, back when we were looking at COVID last March and businesses started closing, and debtors were unemployed, even the court's opinion back then was that we were going to see what they called a bankruptcy tsunami. We've not seen that yet, but there's been multiple reasons. So first, you have your moratoriums that have been in place, that are in place, that some will continue for some duration. That's your foreclosures, that's your repossessions, and really that's going to be a big lever. When those get released and you can start going after your cars and your houses, and people start getting evicted at some point, that's going to naturally lead to an increase. Another factor is government money. We've now had, I believe, 3 stimulus packages, and we don't know for sure, but our feeling is that's extending the increase. So our current thinking, first it was a tsunami last year, that didn't happen. Then we thought maybe Q1 this year, we're a week out from that ending, that's not going to happen. Then the thought was maybe Q2. Personally, I don't see that happening either. We're going to get an increase. The question is, will the increase be what they were expecting, where we were going to see something like your 2008, 2009, 2010 numbers, or are we going to just see a level off to where, you know, the decline stops and maybe we get back to your 2019 numbers? Either way, there's going to be an increase. We don't know. Like I said, I think Q3, Q4, if we're still in the current environment, if COVID keeps decreasing, if there's no more stimulus, and if the moratoriums get released, then I think we're definitely going to be back there. But until then, we're sort of in a holding pattern and a best guess situation. Next slide. So now what I'm going to do is I'm going to cover generally some of the important items with Chapter 7 bankruptcies, and then we'll go into Chapter 13s. So in general, a Chapter 7 bankruptcy is basically a liquidation that's used either by individuals or businesses. Most are individual bankruptcies. The things to know here are, if you have a business that files a Chapter 7, however, it's a liquidation, but unlike a business that files a Chapter 11, the business is going to have to wind down. So the trustee is going to gather any assets a business may have. They're going to liquidate them. They're going to pay creditors whatever they can. Usually it's not much, and that business is going out of business. If it's an individual Chapter 7, the same practice is going to happen. There's going to be in title liquidation, but really, generally, most Chapter 7 individual cases are no asset cases. And so what we mean there is the debtor essentially doesn't have much, but they have a lot of debt. And those cases usually proceed really quickly. You're talking 90 to 120 days from filing to discharge. And usually, especially as an unsecured creditor, so your credit cards, your unsecured loans, you're not going to receive anything. And if it does become an asset case, you're going to receive pennies on the dollar. The debtor in a Chapter 7 will surrender all their non-exempt property to a bankruptcy trustee who will examine if they can liquidate. And in exchange, in that 90 to 120 day window after filing, the debtor will then receive a discharge. Now, one of the key items to watch here is, has the notice of assets been filed? It may be filed at the very beginning because the court and the trustee determine, okay, we already see assets we can liquidate and we can disperse those funds to creditors. 9 times out of 10, they don't. And so it might happen 30 days in, 60 days in, and the trustee will file their notice of assets, and they will set a claims bar date at that point, just as you would see in a Chapter 13. They will mail notice to you as long as you were a creditor that was listed. But it's very important to keep an eye, because at that point, that's your window to at least collect something, because you're already facing a Chapter 7 where you're likely not going to get anything. So it's best to get whatever you can. Now, things to keep in mind there is, if you're an unsecured creditor, it still might not be worth it, because if you're going to incur costs to file a proof of claim, that might be more than what the dividend could be for an unsecured debt. It might still be a losing proposition. But definitely, if you see a notice of assets and you'd like us to file a proof of claim, let us know as soon as possible. And by the same token, if I'm monitoring a Chapter 7 for you, I always watch until that discharge to make sure there's no notice of assets filed. And if there is, I would let you know what the bar date is, and we would see if it's a situation where we could file a proof of claim for you. Next slide. So now I'm going to go over non-dischargeable debt and actually give you an example of one that recently came up, which is just a great example of how this can come up, how it can be an abnormal situation, and what you need to watch out for. So there are certain types of debts that are non-dischargeable just by law, by bankruptcy code. So generally, you're talking your taxes, your student loans, domestic support obligations. A debtor generally cannot receive a discharge on those. Student loans can be a little bit of a sticky situation, whether you're looking at federal loans, private loans, and that's an area that if I had to guess, is very ripe for legislation this year. It's just something that's been in the news. It's been a discussion, and if I had to be a betting person, I think we're going to see some legislation there this year. The question is, what will it be? There's also certain debts that can be deemed non-dischargeable, but that's going to require action on your part. And so those are the debts where you uncover that, you know, the big situation, there was some sort of fraud by the debtor. You know, they lied on their application to obtain your loan, to obtain your car, your mortgage. So, you know, and you might not have seen that until they filed bankruptcy. You might not have seen that until, you know, almost to the point where they're at discharge. Now, something to really keep an eye on here as well is when you receive your bankruptcy notice, you're going to see a deadline for objecting to discharge or objecting to dischargeability. That generally is a hard and fast deadline unless we can get an extension. And if we don't file an action to contest the dischargeability of your debt in that fraud situation, for example, you're out. The debt's going to be discharged. So there are possibilities where we can get extensions. I've got an extension in the past for, you know, we determined through the course of the bankruptcy that something just didn't feel right. We were corresponding with debtors counsel and it wasn't passing the smell test. And we were able to stipulate with opposing counsel to get a 1-month extension to just investigate the matter more. It's not always the case. You know, sometimes you'll have the opposing counsel who, for obvious reasons, it's not in their client's favor to extend that deadline. So it's important to keep an eye on the deadline. So the example I was mentioning that actually just came up in the last month, we were filing a motion for relief. Basically, it was a leased vehicle, and the debtor had obtained the loan back in 2016 and never made a payment. So they make their first payment that they needed to make along with any down payment to drive the car off the lot. They never make another payment. The loan fully matures, and now they file bankruptcy in January of this year. So as a creditor, you're wanting to get your vehicle. So we're going to file a motion for relief. So we filed a motion for relief from stay, and it was basically opening Pandora's box. At the very last possible minute, debtors counsel files a response and says, hey, we're not contesting your request for relief to get the car, but my client doesn't want you to enforce the lease. That's fine, but where's the car? Because our client hasn't been able to locate the car in what is 4 years now, since they defaulted well before bankruptcy. So can you let me know where the car is? And the information they filed with their response was, well, I debtor assigned the vehicle to Joe Smith. Well, most contractual agreements don't allow you to assign a lease or a loan without your permission. And so this person had actually filed suit against this John Smith in a county court, seeking over $1 million in damages, because there was not only our car, but there were 6 other cars that were actually, and all these were luxury cars, that they assigned to this third party, and now that third party went missing. And better yet, which went to our fraud allegation, they assigned our car to this third party less than 1 month after they drove that car off the lot. So where we ended up arriving was we had our motion for relief, and now I went ahead and I filed a adversary complaint alleging fraud and willful misconduct, and we're seeking our entire lease, which is now fully matured and is in excess of $85,000, to be non-dischargeable. We'll see how that works out, but where the debtor is they basically admitted, whether it was knowingly or unknowingly, in their motion for relief response that they assigned this vehicle without permission. And now it turns out they don't have insurance on the vehicle. So that's just a good example of, keep an eye out for those strange things. Every time something doesn't feel right, it might not be that it's fraud, but if it doesn't feel right, reach out, loop us in. We can take another look. We can try to find more information. And this is a great example where sometimes it won't come up until you're pursuing another avenue of recourse, and all of a sudden you stumble on information that you never saw coming. So it's a good example of a non-dischargeable debt. The only issue sometimes with adversary cases, and we could do a whole hour just on adversary cases, is they can get costly. They might not necessarily, but you're going to incur the cost to file the complaint. Then you're going to wait and see, just like in any other lawsuit, is the debtor going to file an answer? If they don't file an answer, it's not going to be very expensive because we're going to get a default judgment. You have your non-dischargeable debt, and later on you go try to collect. But if they file an answer and then we get into discovery, maybe we go to trial, that's where you start weighing at a certain point cost benefit. And if it starts escalating, and I always make sure I communicate that, if we're going to run into where you might be really wanting to go to trial, is it worth expending $10,000 if, depending on the strength of your case and what assets this debtor might have, things like that. So it's always good to weigh as we go along. Do we want to just try to arrive at some agreement with the debtor? That's 9 times out of 10 where they arrive, but just always keep that in mind that sometimes it looks like a great idea, and sometimes things make us upset at what a debtor's doing, but is it in your best interest to proceed? So if you have those situations, let me know, and then we can review those from there. Next slide, please. So generally, Chapter 7 in liens. So what happens with liens? The Chapter 7 discharge doesn't affect your lien rights or your collateral rights. So what is being discharged is the debtor's personal liability. So debtor has a vehicle, you have a lien. When they get their Chapter 7 discharge, you can no longer pursue them personally for the $20,000 they owe you. But what you can do is repossess your vehicle. And generally that'll happen where you have a Chapter 7 and you have 2 to 3 options at this point. The debtor can reaffirm on their vehicle loan or their home loan, and that's the best outcome because you're now removing that from the bankruptcy, and it's basically like a new contract that you can collect on. They can surrender your collateral, your house, your vehicle, or they can retain and pay. Now, technically, after 2005, retain and pay was supposed to become a lesser option. In practice, has that happened? No. We see retain and pays all the time. It could be, and it's even on the bankruptcy forms, on the statement of intent, there's an option. Are you going to reaffirm, or are you going to retain and pay, or are you going to surrender? So it's still there. We might see it in the statement of intent. They may say they're going to reaffirm. We send a reaffirmation agreement, and they say, well, never mind. I just want to retain and pay. It's in the debtor's best interest to retain and pay because they're getting rid of that personal liability, unlike in a reaffirmation agreement where they still are personally liable. But it also gives you a little bit of leverage later on. And the reason I say it gives you a little bit of leverage is you get your Chapter 7 discharge, that personal liability is gone. The debtor, for example, might be current through the bankruptcy. They keep paying you your car loan every month. Well, say we get 2 months out of bankruptcy and all of a sudden they stop paying you on your car loan. Now you can't go and sue them in county court, but what you can do is you can go repo that vehicle. You're completely within your rights. They're not making their payment. Go get your vehicle, liquidate. The important thing to remember at that point is you cannot pursue any deficiency balance. So you repo their car, you sell, you apply the proceeds of the account, you're done. $5,000, $10,000 that's left over, you're out. But at least you still retain those collateral rights. Our recommendation is to at least try to send out the reaffirmation agreement. You might have somebody that says they're retaining and paying, and they get the reaffirmation and they decide, you know what? No, let me sign. It's really a case-by-case situation. Sometimes you don't know, but at least make the attempt and see where you ride, because that's your best outcome. Next slide. So generally, as I had mentioned over reaffirmations, it survives the bankruptcy discharge, and the debtor will remain personally liable on your note after discharge. Another important date, in case you didn't know, it's becoming a trend, dates are important. You will see a date that is called the last date object to dischargeability. I mentioned that earlier in regards to filing a complaint to try to have a debt non-dischargeable. Well, that also applies to reaffirmation agreements. So the important thing to know here is you need to make sure that if a debtor is going to reaffirm, you have to have that reaffirmation agreement signed by the debtor by the last day to object to discharge, and filed as soon as possible thereafter. Because once the last day to object to discharge passes, that case can discharge any moment after. So if you have a last day to object today, there is a possibility that your Chapter 7 bankruptcy could discharge as soon as tomorrow. So if you get a reaffirmation agreement back and the case hasn't discharged and it's signed before that date, go ahead and file it ASAP. And pretty much on your reaffirmation agreements, there's substantial disclosures that parties have to make. You're disclosing what the monthly payment's going to be. Normally, that's your contractual amount. You're going to disclose when the payment's going to be due, when the last payment's going to be. By the same token, the debtor is going to provide financial information. And for any of you who have completed reaffirmation agreements, you know that there are lines within the reaffirmation agreement itself where the debtor provides what was your income at filing, what's your income and expenses now. Big things to know here have to do with presumption of undue hardship. I'll go over quickly. Luckily, credit unions aren't bound by undue hardship. Next slide. So as I mentioned, courts have taken a very strict view of reaffirmation agreements. They regularly require a hearing if the debtor shows it could be an undue hardship. And where that arises is the debtor states that their expenses, which include the reaffirmation agreement, monthly payment, are going to outnumber their income. In that case, there's a presumption of undue hardship. The court's going to set a hearing. And basically that hearing is between the debtor and the court. And where the court will basically question the debtor of, are you sure this is in your best interest? Are you sure you can afford this? Because you're coming out of bankruptcy and there's no get out of jail free card immediately. As I mentioned, the good news for credit unions, you're exempt from this provision. So this won't apply to you, but it's good to know overall, just in case it comes up. Next slide. So one of the biggest questions we get are, I received notice of bankruptcy for my debtor. What do I need to do? First thing, any pending lawsuits or collection actions you have, foreclosures, repossessions that are out there, immediately stay those. If the car is out for repossession, make sure you pull it back. All of those actions are stayed as of the date your debtor files your Chapter 7. The automatic stay covers situations, and the exceptions are very limited. And the situation you don't want to have happen is the debtor files bankruptcy, you get notice, you do everything right, but you forget to pull that car back from repossession with your agent. It's, a couple nights later, that car gets picked up. That's a stay violation. And, those, to put it nicely, stay violations can get messy. They can get expensive. It can entitle the debtor to statutory damages. And it's a reputational issue that you just don't want to have to deal with if you don't need to. There's some debtors attorneys that just, they'll smell blood in the water and they just like to come after you for every little misstep you make. There's some other opposing counsel that we can negotiate with and it'll go away without any problem. But best bet, just make sure you get that notice. You make sure that any pending collection actions at all are stayed. If you have any questions, reach out and then we can go over the situation. You also must wait for the Chapter 7 discharge and the closing of the Chapter 7 case to go after your collateral. So the situation we mentioned earlier where personal liability is discharged, but they're not making payments anymore on your house or your car. You can go foreclose, you can go repossess, but if the case has been discharged but not yet closed, there's a gap in between those two, you could still technically be in violation. So the important date, you will see either a closing date, you will see normally on the docket that the case is terminated. That's the date you're looking for. Many times there's a 14-day appeal period between the discharge order and the termination. So just keep those in mind. There also will be situations where the debtor gets their discharge and this case just goes on and on and on. Either there's something that's out there that the trustee is waiting for, the court's waiting for from the debtor, or the clerk simply forgets to close the case. That happens too. In those situations, we will usually recommend that you file relief from stay to pursue your vehicle. That can be, sometimes can be problematic because you don't know. You could file and that case could end up closing tomorrow. So usually in those situations, we'll take a look at the docket. What's going on? Is there an obvious reason that it's not closing? Let's file. If there's nothing obvious and it looks like there's just a clerk error situation, usually contacting the court and saying, hey, what's up? Why is this case not closing? Either will cause the clerk to go, oh, sorry, it's my mistake, it'll be closed, and you might see it close the next day, or they might say, we're waiting for the trustee's final report. So that's sometimes a good step to take before incurring the cost of filing for relief, but just keep in mind the importance of that termination date in a Chapter 7 case. Next slide. So now that we went over Chapter 7 bankruptcies, we're going to go through Chapter 13 and some big points to know here. So as opposed to a Chapter 7, a Chapter 13 is a reorganization of debt for individuals that have a regular source of income. I mentioned Chapter 11 briefly before. There's many similarities with Chapter 11, but there's also many more complexities. And one thing just to know about Chapter 11s, and then we'll move on to Chapter 13s. Chapter 11s are for businesses and also for specific individual debtors that meet certain income and debt criteria. Your big need to know on Chapter 11, if you get a Chapter 11 filing, my best advice is loop us in. They can be very complex. The dockets can be absolutely overwhelming, and there can be some major deadlines they need to look for that if you miss those in a Chapter 11, especially with disclosure statements and plans, they can be very problematic for you and very binding. So Chapter 11, you get a filing, loop us in, and we'll be able to help you out. So back to Chapter 11. As you know, it involves a repayment plan to creditors over a 3 to 5 year period. Generally, 5-year plan is normally what we see, although sometimes you'll see a 3-year. During the case, the debtor will retain ownership and possession of their assets, but they must also make sure that some or all of their future income is funding that repayment plan so that you receive some proceeds. So it's very important at the outset to make sure the plans are reviewed, and we'll go into why that's so important. Next slide. As I mentioned, the amount of money that a debtor must fund their Chapter 13 plan depends on a few factors. The amount of equity in their non-exempt assets, their income, their expenses, and those items you're going to see in their petitions. And many times they will file their Chapter 13, they will file their petition and their supporting documents in advance of when they actually file their plan. Sometimes everything will be filed together. There's times where they'll file their petition and time goes on and on and on, and there's no plan. So as much as the petition is important to make sure you're listed, the most important item in your Chapter 13 is the plan, because that's going to control so many factors of if and when and what you get paid. There is also the possibility that your account could get paid outside the plan. It's also termed a direct pay, and normally that's how you will see it listed in the Chapter 13 plan. What that means is generally the debtor will pay you directly. It won't be through the trustee. Your payments will come directly from the debtor. Now, if the debtor is in arrears as of when they file their Chapter 13, normally those arrears are going to be cured by the trustee. So you can be getting payments from 2 sources for at least some time. And that's really important to differentiate where you're getting your money from, because later on when we discuss motions for relief, if you're getting funds from the trustee and the account is a direct pay, make sure that those trustee funds are being applied to your pre-petition arrears. So your arrears that accumulated before the debtor filed bankruptcy. By the same token, if you're receiving payments from the debtor and it's a direct pay, you need to make sure that those funds go to the post-petition amounts that come due. And the reason that can be a problem is if you then need to file for relief later on, and you were just receiving this money from 2 sources, and you were just saying, okay, I'm going to apply it to the oldest amounts due. Then when we go to file for relief, we could have a debtor that says, wait, hold on, I actually paid for April, May, and June, and the trustee was curing those arrears. Why are you applying payments incorrectly? And it can just open up situations again that get confusing, could result in your relief being denied and situations like that. So it's really important to make sure that you know how you're being paid, what you're being paid, and who is paying you for what. Next slide. As far as mortgage claims, I sort of mentioned this before in Chapter 7s, the debtor has a couple options. They can surrender the house to you. They can, again, retain the home, pay the pre-petition arrears. Again, normally that'll be through the trustee, through their plan payments, and they will then direct pay your post-petition payments to you. Or the other situation arises where they can seek to avoid the mortgage, but in order for them to be able to do that, they need to have the debt exceed the current valuation of the home. So the situations where this normally arrive is there's more than one lien on the house. So you have, you're not the first mortgage. you have a line of credit and they're underwater, and that house is depreciated, and the house is now worth $150,000, and they have a first mortgage that the balance is $160,000. In that situation, they can avoid your lien. You'll be treated as a wholly unsecured debt, and you're out. But they usually need to take some sort of affirmative action. And the type of affirmative action they need to take, they can either avoid your lien through the plan itself. So again, another reason to really fine-tooth comb looking over a plan when it's filed. They can file a motion to avoid the lien in the main bankruptcy case, and that'll be litigated. Or they can also file an adversary case seeking the same outcome. In addition to going over the plan for those situations, it's really important to keep an eye if they file a motion to avoid your lien or that adversary, because those are going to have hard and fast deadlines where you need to file an answer if that's the path you choose, or else your lien is avoided. And so what are your options if they file to avoid the lien? Pretty much look at your valuation. Can you get your foot in the door that your value is higher? And your value needs to get you to a point where it is at least $1 over what that first mortgage has owed on it. So in our example, you have a value of $150,000 on the house. That's what debtor claims. And that first mortgage is $160,000. And you say, well, no, hold on. The current value that I pulled from Zillow or anywhere else, look for your best value, value shop, says that your value is $180,000. We need to file a response then to that motion to avoid the lien, or we need to file an answer to the adversary, or we need to object to the plan, whichever option they're trying to avoid. And basically our response is going to be, I appreciate that you're trying to avoid our lien. However, the value doesn't allow you to do that. And there can be times where that's enough for the debtor to say, okay, I'm backing off. Normally, it's not the outcome, unfortunately. Sometimes there can be a battle of values. And so you might say, okay, well, here's my value for $180,000. I should be secured. And the debtor says, oh, okay, well, no, I just got a new appraisal, and it says it's not 150,000, but it's 155,000. I can still avoid your lien. And then you say, okay, well, no, let me get an interior appraisal, and your appraisal comes in higher. And so it can be a back and forth. And kind of as I mentioned with the adversary proceedings before, it can get costly. But if it's a situation where you're losing a good amount of money, it can be worth it. So, just keep an eye on those situations, because time is really of the essence when the debtor files to avoid your lien. Next slide. One more item as far as mortgage claims. If your mortgage loan has matured prior to the debtor filing bankruptcy, or it's going to mature during the case, the debtor must pay the entire balance of your loan during the life of that plan. They cannot extend it out past when the plan ends and the case discharges. So that's really important to note. And when we file our proofs of claim on those, we do note that the loan is fully matured, and that just gives another trigger in case the trustee misses it or the debtor misses it, that must be paid in full during the plan. Next slide. Motor vehicle claims. There's some of the valuation issues that can happen here. Also, another reason that's important to timely review the plans or get them over to us. Your debtors must provide secure treatment for the fair market value of the collateral. That could be the NADA value, KBB, Black Book, whatever you regularly use. And so that the fair market is the retail value. Another item to know is that if the vehicle contract was signed within 910 days from before the debtor filed bankruptcy, you must be paid in full. You probably have heard situations where you can get crammed down to that fair market value. Well, if it's within that 910-day window, you cannot be crammed down. You must be paid in full. If they don't list you as a 910 claim, there's a section in the plan for that, you must object. And so we need to get that objection filed by the objection deadline to get that corrected. Those are usually the most straightforward objections because there's really no negotiation room at that point for the debtor. They signed it within that window, you must be paid in full. Now, if it's a value objection, those usually might be situations where we might meet in the middle. Sometimes not. Sometimes we'll say, here's our value, and we're entitled to that value, and debtor say, okay, but usually there's some negotiation involved, and we will arrive there. Another reason you can object to a vehicle claim is because they're cramming down your interest rate. So what you're entitled to, the Supreme Court said in Till that you are entitled to the prime rate plus 1 to 3%. So within the last year, as you're probably aware, the prime rate decreased. Currently, it's 3.25%. So if you have a vehicle loan that is 10%, you can at least try to obtain that 3.25 plus 1 to 3%. If they're bringing you in at 0, it likely is a good idea to object. Now, the situation where you might not want to object is that it's 0%, but your balance is so low that over the life of the plan, the amount of money that increased rate will get you won't be beneficial compared to the cost of filing and litigating an objection. But good thing to keep those in mind. The debtor can also direct pay on cars, as I mentioned. They can surrender their vehicle. And as far as leases, they can assume the lease, they can reject the lease. If they assume a lease, it's important to make sure the arrears are accounted for. If the arrears are not accounted for, you most likely should file for relief and possess your vehicle. As far as surrender, important thing to remember really quickly is that you may get relief from stay by the debtor listing you as a surrender, but you may not. And every plan is different. You may get relief as to the debtor, but not the co-debtor. You may get relief as to neither. So don't just assume because you're listed as a surrender that once the plan confirms, you can go get your vehicle. It can be problematic, and it can still be a stay violation in some situations. Next slide. Other quick important things, you have a small window to object to the Chapter 13 plan before you get a binding confirmation order. Confirmation order, there are very few reasons why you can then file later on to vacate that confirmation order. Basically, only if there's fraud on part of the debtor or there's some material mistake of fact, and there's a very short window and you don't want to have to be in that situation where you do that. And courts are not very willing to entertain those. They tend to be debtor friendly. So again, I know I've probably stressed this many times, making sure you timely review that plan, or once you receive notice, getting the file over to us will make sure that your rights are protected. Make sure your arrears are stated correctly in the plan. Make sure the value is correct. If it's surrender, make sure it's listed appropriately. Make sure your monthly payment amount is correct. They may list you and say you're a direct pay, but they're saying your payment amount is 0. Depending on the language of the plan, you might need to object, as crazy as that sounds, because the situation you don't want to have is that plan to be binding. And also, as I mentioned, make sure your interest rate is either your rate or within that 1 to 3% plus the current prime rate. Next slide. You must file that objection. Generally, the rule, and unfortunately, even though they're federal districts, each district sometimes has its own rules, and that can be troublesome sometimes. Generally, you need to file your plan objection 7 days before the confirmation hearing date. This also applies to amended plans. So you had your original plan, it's confirmed, the debtor files an amended plan or a second amended plan and so forth later on, usually you need to file a plan objection if needed within 7 days of that hearing date. However, especially in Pennsylvania, one thing to keep in mind, Western PA has an even shorter window. You must file your plan objection no later than 7 days prior to the first, so not continued, but the first 341 meeting of creditors date. If you don't do so, the court very well could summarily deny your objection and you're out. So keep an eye on those dates. As I mentioned before, the discharge doesn't affect the mortgage lien holder's rights, absent, again, that affirmative action by the debtor. So your mortgage lien will survive the discharge unless they file a motion to value your collateral, some sort of motion to void the lien, or they file an adversary complaint. Next slide. Quickly with the stay items, many things are similar to Chapter 7. If you have collection action or foreclosure actions or repo, again, you get that notice of bankruptcy filing, stop those immediately. Just avoid the situations that you don't want to be in. Again, you must either wait for discharge and the closing of the case or seek relief from stay to continue with your foreclosure or repossession. Next slide. As far as what exactly is automatic stay, again, it's an injunction which stops certain actions by creditors. You can't collect on your debt from a debtor who filed bankruptcy, and there's also a co-debtor stay in a Chapter 13. Even whether that co-debtors file for bankruptcy or you have a co-debtor on your loan who didn't file for bankruptcy, they are protected by that one debtor filing bankruptcy. It takes effect right when the bankruptcy case is filed. So if it's filed today, it's in effect today. And one of the analogies we like to provide is think of it as a Star Trek protective force field. It is protecting that debtor during their reorganization. And in order to breach that force field, you need to take some sort of action to go pursue the debtor, go pursue your collateral. Next slide. Briefly, this is the actual statutory language as far as what an automatic stay prevents you from doing. As I mentioned, lawsuits, judgments, trying to obtain the debtor's property, trying to obtain new liens, perfect liens, trying to collect or recover any sort of claim against the debtor, prohibited by the automatic stay. You get a bankruptcy filing, don't do it. Next slide. There are some exceptions. Normally these won't apply in our situations, but you see there, criminal proceedings aren't stayed, paternity issues, again, domestic support, child custody, dissolution matters, withholding of income from debtor for other domestic support, evictions. The automatic stay is not going to apply to everything, but in your world, it's going to apply to most everything that you're doing to try to collect from a debtor. So there are exceptions, but they're very limited. And again, get the filing, just stop. Next slide. As I mentioned, there also is a co-debtor stay in Chapter 13. There is not a co-debtor stay in Chapter 7. So in Chapter 7, if you have a debtor that files and there's also a co-debtor and he doesn't file, you can still pursue your non-filing Chapter 7 debtor for the balance, for example. But keep in mind that even though there's not a co-debtor stay in 7, you can't go get that vehicle because it's protected by the filing debtor stay. In Chapter 13, there is a co-debtor stay, but it only applies to consumer debts. So if it's commercial debts, doesn't apply. And as I mentioned, it applies to even that non-filing consumer on your loan. And we'll cover quickly what you do in a situation to try to get relief. Next slide. Termination automatic stay, there's a couple different ways. You may seek relief from stay, or absent you having to take any action, the discharge will terminate the stay. The dismissal of the bankruptcy case will terminate the stay, or you might have a situation where the case closes without a discharge, and in that situation, your stay also has terminated. Absent those situations, you're normally going to need to file for relief. Next slide. So when you seek relief from stay, you file what's called a motion for relief from stay. You're basically seeking to be able to collect against the debtor and the co-debtor. You filed foreclosure, they then filed a bankruptcy case, that stayed the foreclosure, you had to stop your repossession, it might have stopped a foreclosure sale, you need to get relief to continue on. So what you must establish are a couple things. So you first must establish that the debtor is not keeping their payments current and that you're not adequately protected. So what that means is post-petition, so post their bankruptcy filing, they're not maintaining their payments. And generally right now, the courts look at the magic number of 60 days. So they filed their bankruptcy, they haven't made payments, and the payments that have come due after their filing are 60 days past due. If it's in that situation, get the account over to us, we'll proceed with filing for relief from stay. Another criteria that we must attest to in our motion is that there is little or no equity. So you're wanting to file for relief on your vehicle, they're past due more than 60 days. However, that vehicle value is $15,000 and your balance is $5,000. You're probably going to run into an equity issue where the court's going to say, great, your debtor's not paying. However, because you have that $10,000 equity cushion, you're not entitled to relief. You're protected until that value gets down to at or below your balance. Now, I would say just because you have some equity cushion, don't think that as a hard stop that you shouldn't file for relief. How big of an equity cushion is it? Sometimes it's case by case, it's judge by judge, it's district by district. So if you have concerns, let us know and we can take a look. One other item where you can file for relief from stay is because the debtor canceled their insurance on the vehicle. You are now not adequately protected. Your vehicle could sustain a loss and you're not going to receive insurance payment. That is a valid basis to file for relief from stay. And in that situation, it may be that we file and the debtor then provides proof of insurance. It may be that they don't have funds to do that and you get relief and you go to your vehicle. So those are all things to keep in mind. Next slide. And quickly to get through here, since we're running late, in Chapter 7 cases, your delinquency we're talking about, we have used both pre and post-petition payment delinquency. In Chapter 13, you also use just post-petition. So keep those in mind, different calculations. And I'm going to skip to the end here really quick so I can cover legislation really quick because we have a few questions and we're over time. So if we can go to the last slide. So legislation, there actually have been some things recently. As I mentioned earlier, Congress is very ripe. We've had a switch in control of Congress. We've had a pandemic. We may be facing bankruptcy changes. The one thing that may stop that is that there's a very tight divide and they might not have enough votes to make drastic changes. We're keeping an eye on that. We'll see what happens. There was legislation that was introduced late last year by Senator Elizabeth Warren, which hasn't moved anywhere yet, but it may, since they're moving past some of the other legislative issues, which sought to get rid of the current chapters in bankruptcy and introduce just a Chapter 10. It's very debtor friendly, and we'll keep an eye on that as well to see what happens. That would have very big ramifications for your world and for our world. There was legislation that was introduced in February that tried to make changes based on a debtor that's filing that has excess medical debt. That one was even sketchier with details. We're keeping an eye on that as well to see what happens. And there also was, as you probably remember from last year, the CARES Act. And then there was the appropriations bill in December. There was just legislation introduced in the last month to extend the CARES Act and the appropriations bill relief in bankruptcy. That actually just passed. It passed the House a little while ago, and yesterday evening it passed the Senate. So as of now, that is awaiting President Biden's signature. Once that happens, I will be sure to send out an alert and let everybody know of what that means for your world. So as I said, time will tell. We'll see what happens, but we're keeping an eye on legislation to see how that might affect your current and future environments.
All right, Gary, thanks. That's obviously there's a lot to cover and we're short on time, but again, if anyone has any questions, certainly reach out to Gary. He's always great to answer questions and help out. And like I said, a lot of stuff in there. Before we wrap up, there are a couple questions that we'll go over, but before we do that, just want to again thank everyone for attending today. We will send you a copy of the materials with all of our contact information. Feel free to reach out to any of us. We're certainly here to help in any way, shape, or form. Also, if anyone has any issues regarding return to work policies for staff or vaccine issues on the employment side, we can assist with that. Reach out to me and let me know. My partner Matt Young handles a lot of employment issues, and he's been working on those particular topics for several different credit unions that we represent. So if those are things that are going to be of concern, and they might be, especially with whether or not you're going to require vaccines and things of that nature for COVID, certainly reach out to me and we can assist. So as we move forward here, let's wrap up, Gary, with a few questions. The first question I'll actually go ahead and answer, because it says, if a judgment is entered and docketed as a statewide lien on property, does this survive bankruptcy? Does it still need to be paid when property is being sold? And the answer to that question is yes, unless there was some sort of avoidance of that lien. That judgment lien exists. There's no personal monetary obligation that you can't try to collect for that debt because it's been discharged. But if they didn't avoid the lien, which happens a lot, especially in Chapter 7s, and you have a pre-filing judgment lien, that's going to have to be dealt with at the time of closing. We get a lot. I get a lot of payoff requests for people trying to clear those debts. So that's the answer to the first question. Gary, so what about debts that are taken out shortly before bankruptcy is filed? I know that they are supposed to be non-dischargeable, but have you ever had success in getting the courts to approve these?
Yes, we've had success. Generally, you need to look for previous 90 days before bankruptcy. If you have a situation, what we need to examine is how much is that debt? How much is it going to cost you to basically file your motion or your complaint, and what's the likelihood of success? So we've had success. We've had success with luxury items close to bankruptcy filing. Really, it's unfortunately it's a case-by-case basis. So if you ever have those situations come up, feel free to get us involved and we can take a look and give you the pros and cons.
Okay. Is overstating income on a loan application considered fraudulent for purposes of filing non-dischargeability? What if the credit union does not ask for income verification?
So we can certainly plead that it is fraud. The hurdle is going to be, A, was it willful? Did the debtor actually lie? Can you prove, and that could come out in discovery, or are they going to make a claim, it was, I just happened to write the wrong amount, I happened to write a wrong zero, things like that. So my advice is it's reviewable, and it's a good idea to take a look. And same with the preference claims, case by case. It would depend how strong of a case do you have.
Okay. And it looks like the last question we have in here is a Chapter 13 question. If a debtor lists the credit union debt in the petition, however, the creditor missed the deadline for filing a POC, proof of claim, what can be done to be able to get this claim to be accepted and paid? Does the listing in the voluntary petition automatically create a claim for the creditor?
So unfortunately, in a Chapter 13, no. In Chapter 11, many times yes, but in Chapter 13, if you miss the claim deadline, you may be out. Now, my recommendation would be, generally, if you miss a claim, get it over to us, because 9 times out of 10, we can just simply reach out to debtors counsel, say, hey, would you oppose it? And normally they'll say no. And it's especially if it's a situation where it's a secured debt, they want to keep their car, they want to keep their house. It's not in their best interest to not pay you. So if you have the situations, reach out to us. 99% of the time, debtors counsel will say, no, I don't oppose it. We'll get a late claim filed and there'll be no issue from the debtor. The trustee might have issues, but generally, even if we draw an objection from the trustee to that claim, simple call, simple email to the trustee and saying, hey, I have it in writing here. The debtors counsel didn't oppose us filing the late claim, and that usually will be good enough. So normally, no problem, but we need to make sure to reach out first.
Okay. And the bird is not chirping in my office because I'm on the 25th floor, so it might be.
It's
might have
mine.
a friend outside your window there.
Yep.
But anyhow, Gary, thanks a lot. We appreciate it. Again, everyone, thanks for attending. If you have any ideas or suggestions for smaller, like 1 hour topics that we can do, again, I have a couple ideas, but we'd like to hear from you. Feedback on the presentation, feedback on anything. We certainly would appreciate it. So it was great to be with everyone today. It's good to be back with my credit union friends, and I'm certainly hope that we can help you moving forward, and anything you need, we're here. Thanks again. As I mentioned, you'll get a copy of the presentation, but you will also the presentation is also available. The recording is also available as well. So with that being said, this will wrap it up, and thank you. And I hope everyone has a great day, and look forward to seeing you soon.